affidavit filed by the respondents. Also, it is submitted that the said edition, the rejoinder would be filed.
Well, I am not actually, I may not be filing rejoinder, but I
Okay.
want him to come over and go through it once.
Mr. B. Burma, learned counsel for the petitioner, submits that the matter be taken up on
27th of
27/8/2026, inasmuch as the audio clip annexed to video clip annexed to the additional affidavit is required to be perused in presence of the petitioner, who, due to some unavoidable circumstances, could not come down to Gauhati for the same. Also, it is submitted that before the next date of listing, the said audio clip would be viewed in presence of the petitioner, and submissions thereon would be made by the learned counsel for the petition. Prayer is not objected to by Ms. M.D. Bora, learned standing counsel, Transport Department. Registry, prayer accept, accordingly, registry to list this matter again on 27/8/2026. No further adjournment shall be granted.
Deeply obliged.
I just wanted to know if your lordship should be video.
No, I'll not go. I'll go with the readings only.
The affidavit also we have.
Affidavit, they have given the thing.
It has become things very
I
difficult
don't
for
know
me.
whether that, that has a virus or something. I put it here, all my
yes,
data
yes,
would
yes.
go. Why should I take this?
Fine.
I say we can
You
display-
dispute that transcript, then I will look into it.
Not
Okay.
open.
Yes,
Lord, I beg to mention,
It will even for further hearing.
for further hearing.
For further.
Obliged.
I beg to mention item number 37, my lord. It's a contempt case, my lord. The petitioner already died in this case.
Substitute him. What do you want to do? What do you want to do?
I have informed the court that he died, my lord. If
Then there is none to
Substitution is
press,
allowed,
I'll have
then-
to close it.
lordship
there-
may close it, ma'am.
It is submitted that, your name?
Yes, Upadhyay, ma'am.
Mr. S. Upadhyay, learned counsel for the petitioner, submits that during the pendency of the present contempt petition, the petitioner, petitioner passed on, on,
Exact date, we don't know, my lord, last year.
passed on in the year 2025. He submits that none of the members of the petitioner's family have come forward for substituting themselves in the present contempt petition. Accordingly, he prays that the present contempt petition be closed. Prayer accepted. The present contempt petition stands closed on being abated.
Deeply obliged.
May I hear your lordship? Lordship, I beg to mention for listing of a writ petition, lordship. Lordship, on the last occasion, the interim was granted till 21st of August, but the matter was fixed on 28th of August, lordship. So,
This court passed the order.
no, lordship, court number 7, lordship. Much of. And please, lordship, I beg to mention for listing, one, writ petition civil relating to service of teacher provincialized school for admission.
Milai Dini. Speak second. Yes. I have received the badge.
You're
You
supposed
have
to,
received it last week. Last time you wanted to go through it. Have you gone through?
Yes,
What
I
is
have
it?
got through.
What is your submission?
My submission is, my lord, marks are as claimed by the petitioner is not correct.
Hmm.
He got in a ballot Viva versus 23 and written.
How do you say that?
I have gone through it. I have given a flag, my lordship can check it, my lord.
No, you make your submissions what it is.
lordship may take up item number 4.
Item number?
4.
Go to book file it and again, same matter. Same matter. Side of a fight. Proceed,
Yes.
Bourbon.
Mr. Chutia,
Yes, madam.
give him 5 minutes, just recap the thing.
That's it.
Yes.
Look, I have submitted a short
Ah,
synopsis.
ah.
The selection process by direct recruitment was undertaken by the Director of Economics and Statistics, my lord, for filling up of 43 numbers of posts, my lord.
Hmm.
There are two advertisements. One advertisement dated 8/8/2008, and advertisement dated 22/5/2009. Next are 1 and 2. Their selection process comprises of 100 marks. in-
Total post is 43 in
43.
both the advertisements.
My lord, total.
Hmm.
Uh, Selection process was comprised of 100 marks of written test and 30 marks of viva voce. Field assistant in the Directorate of
Hmm.
Economics and Statistics.
Hmm.
Well, this service is governed by the Assam Economics and Statistics.
Both are general.
One is OBC, my lord, item 3.
Three.
And item 4 is general.
Item 3 is WPC 5693.
Total is general.
Okay, then what happened?
Well, this service is governed by the Assam Economics and Statistical Junior Service Rule 1980.
Hmm.
As per Rule 17, my lord, that there is a constitution of selection board, my lord,
Hmm.
is comprised Directorate of Economics and Statistics. That copy I have furnished.
Hmm.
Rules, my lord. Senior most Joint Director of Economics and Statistics,
Hmm.
Deputy Director of or Undersecretary nominated by the Secretary Planning and Development Department.
Hmm.
Rule 17, my lord.
Hmm.
In Rule 6, my lord, says the direct recruitment, my lord. May read the provision, my lord. Direct recruitment, there is cadre of sub-inspector, control operator, data entry, supervisor, artist cum draftsman, artist cum photographer, primary investigator, well, that, field assistant and so and so post shall be made by the appointing authority on the basis of recommendation made by the board in accordance with the procedure herein provided.
Hmm.
Before, first is not relevant, minute,
Hmm.
second minute. The appointing authority shall then invite application through advertisement in accordance with the general instruction in force.
You're reading from
And I am reading Rule 6B,
B,
1B.
1B. Hmm.
The general instruction in force. On receipt of the application in response to the advertisement, the appointing authority shall prepare a statement of the candidates and forward it to the board together with copies of the advertisement in original application and such other information as may be considered necessary. The appointing authority shall simultaneously request the board to recommend the candidates in order to preference of appointment.
Hmm.
Next is important minute. The board shall make the selection in accordance with the scheme of the selection prescribed by the government, holding interview and undertaking the scrutiny of the candidate and other documents as may be considered necessary. After selection, the board shall recommend the list of the candidates found suitable for appointment to the appointing authority in order to preference which shall constitute the select list. The appointing authority shall consider the list prepared by the board and approve the same unless it considered to change necessary. If the appointing authority considers it necessary to make any change in the list received from the board, it shall inform the board of the change proposed and after taking into account the comments, if any, of the board, and may approve the list finally with such modification, if any, as may in its opinion be just and proper. The approved list shall constitute the select list. The appointing authority shall publish the select list as such places as it may consider. Now, what happened, my lord? Petitioner in item 4, his general category candidate, he applied. He was called for to sit in the interview, my lord. Results were declared in the Assam Tribune Daily dated 9/11/2010, annexure 4 at page 21.
Hmm.
He was
The roll
declared,
numbers were there, 37 candidates were selected.
my lord.
Then you project that the cutoff marks was
80.
70
70 for the general candidate.
general candidate
Yes.
and 80, you got 80
80.
and 24.5 in the
Viva.
Viva and
Viva.
total 104.
104.5.
So petitioner in WPC 5701 got 80 plus 24.5, 104.5.
That's it.
Now in A, petitioner that WPC 5693,
That he got 80 in Viva and 24 in 80 in written test, the 24 in Viva.
okay. Then what happened?
Lordship, then when the result declared valid, only the roll numbers were declared valid. And it was found that petitioner find place in the written test and both the petitioner, they were called for the promotion. The respondent number 3, 4, respondent number 3, 4 and 5, their name, their roll numbers are not there. Subsequently, the results were declared valid. It was found that the respondent number 3, 4 and 5, even they did not qualify in the written test, they were included in the final list for selection.
First notification is of 26/11/2010.
My lord.
Hmm.
On inquiry, they came to know that that their marks were deducted from 80, and subsequently in the second batch of in first batch of revision, in the second batch of revision, it was to 75 minutes.
So, but they were later included in the appointment list.
That respondent 3, 4, and 5, they were included in the appointment. So you will find that annexure 7, the name of the private respondents are there.
Then what happened?
At that point, my lordship, this petitioner came before this honorable court.
The other one had not come.
Both of them came.
You filed WPC
That petitioner in
413
lordship,
2010.
lordship.
Ah.
That petitioner in item 3, my lord. And petitioner in item 4, she filed 6413 of presentation.
Then what happened?
In the
That
state
affidavit they
case,
admitted.
affidavit filed by the director of economics and statistics at page 25 of the registration and annexure 8. At paragraph 5, my lord, he stated that, may I read, my lord?
That we have got.
Yes.
Then they took a decision to
Re-evaluate.
re-evaluate.
Yes, my lord. To re-examine the answer script of the candidate securing 70 marks and above on sample basis. That is under challenge, my lord. The rule says that any decision regarding the selection that has to be taken by the board, my lord. In the affidavit filed in the first batch and the second batch, it doesn't disclose that there is any decision of the board in taking the decision of re-evaluation.
Hmm.
That is the basic challenge.
Yes, then
In the earlier batch of repetition, there are 5 repetition manner. One was the WBC 6.
that is by you, and the other one, the Adhir Chandra Das, Asim
Asim.
Moment, which,
Asim Burman.
that is which writ petition?
Repetition, he preferred the 6414 of 2010 in the earlier bit.
Okay. What
And
is the direction there?
Both the repetition are hard together, on the common order of company. Before that, I am taking your lordship to the page 25, annex 8. This is another affidavit in the page of repetition. Sorry,
Page? Page?
Page 31. Same page of repetition, WPC 433 of 2011. It has been categorically admitted by the director at paragraph 4 down below. You will find at page 22. It is to be mentioned that the service of some selected official of the Director of Economics and Statistics Assam were utilized for evaluation of the answer script of field assistant and not by the members of the committee constituted by the Director of Economics and Statistics for conducting the written examination as alleged by the petitioner. Then at page 35 regarding the appointment of the private respondents, paragraph 9 second paragraph. Although call letters of the successful candidate qualified for interview, including the above mentioned 3 candidates regarding that private respondents were dispatched considering the marks secured by them in the written examination. But in the result of the successful candidate published in the newspaper were either published wrongly or dropped due to typographical error occurred while sending the name of the Director of Information and Public Relations Assam for publishing the newspaper. Sri Dilip Das, roll number so-and-so was published in place of so-and-so. Sri Mausimi Das, roll number so-and-so, and Sri Hemunda Das, roll number so-and-so were dropped. And provision was issued in respect of Mausimi Das case. In case of other 2 candidates, error detected very lately, so no provision was issued for the same, as the call letters were already issued to the candidates to the individual communication address. Further, no candidates bearing roll number have turned up to appear in the picture for Viva Similar. These 3 candidates that did not qualify in the written exam. That has been categorically admitted, but their names are not there. One provision was issued in respect of 1 candidate, and regarding that to other candidates, there is no provision.
So the other 2 candidates means you both. The petitioners.
No, that private respondent.
No, in a case of other 2 candidates, the error
My
detected,
trick is Mausumi.
that we have got it.
Yes,
But corrigendum was issued in case of Mausumi Das,
Yes.
not the other 2.
Not to the other one. Dilip and Hemanta. Now your lordship will find that common judgment at page 40, it starts from page 49.
So how was this 2 appointed then?
Yes, that is also under silence. Their names are not in the past list of the written test. No corrigendum was issued. Directly they were appointed.
Then what? Where is the judgment?
Yes, it starts from page 49. Lordship will come directly to paragraph 7, page 51. Made by successive orders, and to be precise, by orders dated 12/6/2014, 15/7/2014, and 5/8/2014, the Director of Economics and Statistics, Respondent 2, was directed to produce the answer script of the petitioners. However, there is no production of the same. Mr. Talukdar, State Council, submits that he has not received any instruction in this regard from the Respondent 2. Having regard to the nature of allegation made, it was incumbent on the part of the Respondent 2 to produce the relevant answer script. In absence of production of the same as submitted by Mr. Guya, learned counsel for the petitioner as adverse inference is required to be drawn. As stated in petition number 433, as against the 81.5 marks secured by the petitioner in the written examination, the same was reduced to 77 by subsequent re-evaluation, authority of which has not been disclosed in this counter affidavit. The said petitioner secured 21 in the oral interview out of 30. Similarly, in petitioner involved in WPC 6413, that Osim Burman here, also been provided with lesser mark in the subsequent state of privacy segment of this selection, as has been contended by the petitioner as against the original 24.5 marks secured by him in the privacy segment. The same was subsequently reduced to 23. In WPC 6414, that item number 4, the petitioner secured 80 marks in the written examination, which was subsequently reduced to 76. Similarly, in the privacy segment also, marks secured by him reduced to 15 at the later stage. In other petition, that is 64 in 2010, he is not further achievable.
So this matter was remanded back to the authorities.
That's it.
to
That's
take
it, but
a
Lordship will
fresh look
have
at-
that observation made by this court also. Paragraph 11, made report.
Hmm.
Page 52. The above aspect of the matter will be have to consider in reference to the stand of the respondent in their counter affidavit regarding reduction of mark. At paragraph 4 of the counter affidavit, while admitting the original marks secured by the said two petitioners, it has been stated that answer script of the candidate securing for 70 marks and above has been re-examined on sample basis. It has
No,
also,
Mr. Hazarika, one thing.
well,
The initial after the advertised,
well,
you applied, you were given the call letters and all. Then who conducted the original selection?
so it was that the appointing authority is the director of economic.
No, who conducted was the selection conducted by the written examination conducted by the selection board? Or the selection board came into being after the written examination?
That is not clear, Millet, that the advertisement was published. by
Because
the-
you find it that the rules does not mandate that the written examination is also to be rule 17.
This is the board, constitutional board, Millet.
You have the full rules with you.
Yes,
Just give me the rules. This rule only does not contemplate of a written examination.
Millet, it says interview, Millet.
Huh?
It says interview.
Interview.
Interview, Millet. And the lordship will find that rule 17, that director of economic and statistics is the chairman of the board, Millet. And the interview advertisement was issued by the chairman, and call letters were also issued by him. That it may come to paragraph, I was reading paragraph 11 of the judgment, Millet. Mayor. It has also been stated that to avoid any allegation of bias approach, all the answers above securing 70% and above had been re-examined. Upon such re-examination and depending upon the methodology and answer script of the question, answering question, spelling mistakes in totaling, etc. in the same of the answer script, total marks secured by the candidates had been reduced. However, there is nothing to indicate that any decision was taken by the selection board to adopt the said procedure. This is also, there is.
You can have read it. You can come to para 14.
Lots. Yes, madam. All the representatives are disposed of and directing the respondents, more particularly the respondent to re-examine the case of the
So
petitioner.
respond number 2 is the director.
Director, madam. Particularly the respondent to re-examine the case of the petitioner in reference to the above available materials on record and consistently with the observation made above and thereafter to pass an appropriate order. Let the required exercise in terms of the order be carried out as expeditiously as possible, preferably within 2 months. Well, Lordship will see there are two observations regarding the petitioner and regarding the private respondents regarding the selection.
But the final thing, there is no direction with regard to the private respondent.
No, there is observation. There is
Where?
a 14 says, yes, madam.
Where is that observation? This court noticed everything, but
Yes.
only said they re-examine the case of the petition.
That's it, madam.
And it did not say that the reduction of the marks were bad. It did not say that. It did not interfere with the,
So Lordship, that is honorable court observed that there is no decision of the board because it is mandated under the rule 6(2). Everything has to be by the board.
okay, we'll see. Then what happened? After this order?
That's it, impugn order came, madam. Lordship will pay private page 55, annex of 14, madam. This is in respect of Jyotirmoy Sotri. With reference to your petition that is showing, so it is to inform that as per common judgment and order passed by the Honorable Court dated 19/8/2014, a team of officers, madam, again, madam, of this directorate have been engaged to conduct the joint examination of the answer script of the written examination of all 4 petitioners, including you, madam. There is no indication that there is a decision of the board to re-examine by these officers. And in the affidavit also, they have not stated that this decision was taken by the court. During joint examination of your answer script, the marks secured by you has been decreased to 75 out of 100 from earlier re-evaluation marks of 79.5 out of 100. The joint examiner detected grammatical mistake in respect of sentence construction in English, partially correct answer with spelling.
And the other one, how much he got?
That's it.
Other person?
Page 59 of that.
Marks written, how much he got?
Yes, ma'am. It was 77.77 half, madam.
And
It was
Viva?
increased, it said to be increased, madam.
Okay, Viva?
Viva, madam, 15.
Okay. So this is what you are agreed to.
My lord, my basic challenge is that there is no decision of the board to reduce or increase the mark, madam. It has been taken by the director of economic service. And my categorical statement, they have not denied, madam. They have not shown that any decision the board has taken to re-evaluate the mark. And this is in violation of rule 6 of it. It has to be by the board under rule 70. Not rule. The officers, they cannot, madam, unless there is a decision of the board.
Okay. Anything more? Mr. Chitian, let
Yes.
me just take down his submissions. We pass a common order,
Not
WTC number 5701/2014 and WTC 5693/2014. The petitions in the above, I heard Mr. P. Hazurika, learned counsel for the petition. I also heard Mr. T.C. Chutia, learned additional senior government advocate appearing for the state respondents. And Ms. K.K. Chaudhary, learned counsel appearing for the respondents number 3, 4 and 5. Full stop. The petitioners in the above note, by way of instituting the above noted writ petitions have essayed a speaking order, both same date, both dated 17/4,
Yes.
2014, rejecting their claim for being recruited against the posts of field assistant advertised wide advertisements dated 8/8/2008 and 22/5/2009. Also, the petitioners in the above noted writ petitions in pursuance to the advertisements dated 8/8/2008, next cycle, 8/8/2008 and 22/5/2009 had submitted their respective applications for a recruitment against the posts of field assistant in the Directorate of Economics and Statistics, Assam. Also, the application submitted by the petitioners being found to conform to the eligibility criteria as set out in the said advertisements, the petitioners were issued with call letters for appearing in a written examination. Also, the petitioners accordingly appeared in the written examination and on also the petitioners project that they having performed exceedingly well in the written examination, they were directed to appear for a viva voce. They were directed to appear in the viva voce segment of the selection process. At this stage, it is to be noted that in terms of the said advertisement, the selection was to comprise of 100 marks, out of which 80 marks was to comprise of 130 marks, out of which 100 marks were earmarked for the written examination, while 30 marks was so earmarked for the viva voce segment. Also, thereafter, the petitioners appeared in the viva voce segment of the selection process. Also, the results of the said selection came to be published in the News Daily Assam Tribune in its issue dated 26/11/2010. Herein, the petitioners found that their roll numbers did not figure. Also, subsequently, while an order dated 30/11/2010, the respondent number 2 published a select list and therein reflected the names of the selected candidates. Also, the petitioners found that the names of the respondent number, roll numbers of the respondent number 3, 4, and 5 were not found to be included in the list, a select list as published in the News Daily in its issue dated 26/11/2010. However, their names were found to be incorporated in the subsequent select list dated 30/11/2010. Also,
Little correction.
Huh?
In the written test, madam, in the result of the written test, there is no name shall not.
this is a written test.
No, well, this is the after the final,
Okay,
But,
Lekhaji,
26 November, madam, is 23.
okay, it is what Lekhaji, found that although the names of the respondents number 3, 4, and 5 were not incorporated in the list so published after the written examination, their names were found to be published in the select list published on 26/11/2010 and 30/11/2010. Also, it is further projected in the writ petition that although the selection process, recruitment was so initiated for filling up of 43 vacant posts of field assistant, only 37 candidates were selected for the purpose, and the remaining vacant posts were projected to have been so filled up by way of appointment of candidates on compassionate terms. Next one, being aggrieved by the exclusion of their names from the select list of the post of so-and-so, the petitioners approached this court by way of instituting WPC number
6413 and 6414.
6413 and 6414. 6413 to 20 PB.
6413 by Jyotirmoy.
Jyotirmoy Chaudhary versus State of Assam, and 6413 Osim Burman versus State of Assam, right?
Right.
No, 6413
By Jyotirmoy.
Jyotirmoy Chaudhary versus State of Assam, Aru 6414 by Osim Burman versus State of Assam. 2010. So, the said petitions were taken up for final consideration by this court, and wide judgment and order dated 19/8/2014. The said petitions, along with other analogous matters, came to be disposed of, remanding the matter to the Director, Economics and Statistics, Assam, directing him to re-examine the case of the petitioners in reference to the available materials and consistently with the observations made in the said judgment and order, and thereafter to pass appropriate directions. In pursuance to the said directions, the Director, Economics and Statistics, Assam, wide communications dated 17/10/2014, issued individually to the petitioners in the above noted petition, proceeded to reject the claim of the petitioners for an appointment, holding that on a re-examination of their answer scripts, the petitioners were found to have secured marks below the cutoff marks as obtaining in the selection process for the general community as well as the OBC community. Also, being aggrieved, the petitioners have instituted the present petition. Mr. P. Hazurika, learned counsel for the petition, after reiterating the facts noticed herein above, has submitted that the recruitment exercise as initiated while the advertisement dated 8/8/2008 and 22/5/2009 is covered by the provisions of the Assam Economic and Statistical (Junior) over Service Rules 1980. He submits that in terms of the scheme of the said rules, more particularly provisions of Rule 6 thereof, it is the selection board as constituted under Rule 17 that is to hold the selection in question. He submits that from the provisions of the rules, more particularly Rule 6 thereof, the selection cannot be held by any authority other than the selection board. Also, Mr. Hazurika has submitted that from the pleadings brought on record in the earlier round of litigation, that in WPC number 6413/2010 and 6414/2010, it is clear that the petitioners in the selection process had secured 80 marks each.
Well,
80 marks each.
80 marks.
80 marks each in the in the written examination and had secured
24.5 and 24 respectively.
and had secured 20
4.5 by Supreme Court and 24 by Austin.
24.5 by the petitioner in WPC number 5701/2014 and 24 by the petitioner in WPC number 5693/2014. Accordingly, he submits that the cutoff marks being 104, both the said writ petitioners had been secured more marks than the cutoff marks, comma, they were entitled to be appointed against the post of field assistant so advertised. He submits that the fact that the petitioner had scored the said marks was more particularly in the written examination,
In respect of OBC Miller, there is cutoff mark of 99.5.
a 104 question for general and 99.5 for OBC. With of 99.5. Correction was more particularly the marks scored by the petitioners in the written examination was admitted to by the respondent authorities. So, Mr. Hazarika submits that in the affidavits filed by the director in the earlier round of litigation, it was brought on record that a re-examination of the answer scripts of all the candidates securing more than 70 or more marks in the written examination was undertaken, and on conclusion of such re-examination, the marks secured by the petitioners stood reduced, and accordingly they were taken out of the purview of the and accordingly their merit position now being assigned much below than what was originally assigned to them, the petitioners were not appointed against the advertised posts. Mr. Hazarika, by referring to the appointments effected in respect of respondents number 3, 4, and 5, has submitted that the names of the roll numbers of the said respondents did not figure in the list of candidates who were declared to be successful in the written examination. However, he submits that the names of the roll numbers and subsequently the names of the respondents number 3, 4, and 5 came to be published in the select list as published in the matter after on conclusion of the selection exercise. Mr. Hazarika has further submitted that the respondent authorities in the earlier round of litigation in the affidavit so filed had made a categorical statement to the effect that there was an anomaly which had resulted in dropping of the name of the respondent number 3, 4, and 5. However, a corrigendum rectifying the dropping the anomaly so occasioning came to be issued only in respect of the respondent number 3, and there was no corrigendum issued towards incorporating the names of the respondent number 4 and 5 in the
Respondent 4 origin number.
respondent number 4 corrigendum 3 and 5. Forward corrigendum was 3 and 5 in the list of candidates who were declared to be successful in the written examination. Accordingly, he submits that the selection of the respondent number 3 and 5, at least the selection of the respondent number 3 and 5, would mandate an interference by this court. Mr. Hazarika, by referring to the judgment and order dated 19/8/2014, passed in WPC number 616
6414
6314 and 6313 2010 submits that the coordinate bench of this court therein had noticed all the anomalies that had occasioned in the selection process, and it is in the background of the such anomalies noticed by the coordinate bench that the matter was remanded back for a re-examination by the respondent number 2. He submits that the coordinate bench in the said judgment and order had categorically mandated that the re-examination should be so effected in consistently with the observations made with regard to the various aspects of the selection process, in the said judgment and order. Also, Mr. Hazarika, by referring to the order dated 1710 to the communications dated 1710-2014 as issued to the petitioner, submits that a perusal of the same would reveal that the re-examination of the answer scripts admittedly was not done by the selection board, but was done at the instance of the respondent number 2 by a committee, a committee of joint re-examiners as constituted by him in the matter. He submits that the rules, more particularly the provisions of Rule 6 read with Rule 17 of the said rules, having mandated that the selection process would be so conducted solely by the selection board and not any other authority, the exercise as carried out purportedly in compliance with the directions passed by this court in the earlier round of litigation by the respondent number 2 would not mandate an acceptance from this court, and the same would be required to be interfered with. So, in the above premises, Mr. Hazarika submits that the respondent number 3 and 5, admittedly not being incorporated in the list of successful candidates who were called for the viva voce examination, their subsequent appointment being clouded in mystery would mandate an interference from this court, and the petitioners would now be required to be directed to be appointed against the said post with retrospective effect, that is, with effect from the date the other candidates selected in pursuance to the advertisement in question were so appointed as field assistants. Anything more? Yes, Mr. Chief.
And in my reply, I have stated that there are some vacancies as of 49 vacancies.
That is not in the selection process. Yes.
My lord, as directed by your lordships, my lord, I have received the instructions and the marks obtained by the petitioners and others. First of all, my lord, what happened? He says that some records were not produced by the respondent, my lord. It was mentioned that written exams of has already been submitted to the deputy. Available office records or original records relating to the marks were awarded to 2 read petitioners as well as the other candidates in the written examination, and viva voce have already been submitted to the Deputy Registrar, Judicial 3, Gauhati High Court by letter.
Okay, forget those. Those are.
No, that's why, my lord, he says
submissions.
original record that was submitted is still in the, my lord, High Court. And however,
These are not open, these are duplicate records.
they did not duplicate, they have kept the photocopy, I think. Photocopy. And still, but they have said, yes, on 12 January 2015, they have sent to the, my lord, register. However, my lord, marks obtained by the petitioner, my lord, I have seen here, my lord. In a petitioner Chaudhary, Jyotirmoy Chaudhary, he received marks, my lord. Yes. 170 Jyotirmoy Chaudhary, male, and is a, my lord, general. Marks 80. He received, my lord, 80, and viva 8.8.7103 before re-examination.
Viva how much?
Viva 8 plus 8 plus 3, 23, I think.
8 plus?
8 plus,
Huh.
plus 7. 16 plus 17, that is 23. And written source, my lord, 80 marks.
So 103.
Yes,
And
my lord,
Osim,
and Osim got OBC and 5 marks in the Viva. Huh? One is 5.
how much did he get in the Viva? How much did he get in the written examination?
Written examination, my lord, that is Osim.
Hmm? Okay, give me the records.
My lord, I got it. Osim, my lord, got it, my lord. 76 written and Viva 5 plus 5 plus 5 plus 15, that means 91.
91.
91.
Okay. Then what do you say about the respondents number 3, 4, and 5?
Respond number 3 and 4, my lord, I will have to check it, my lord. I did not check it, my lord.
Madam, how much did respondents number 3, 4, and 5 get? What are the names of the respondent number 3?
My lord, respondent 3 is Philip Das. Respondent 4, Mosumi Das. Respondent 5, Hemanta Das.
Mosumi. Other two are general.
More than the petitioners. They got much more than the petitioners.
Mosumi Das. Mosumi Das got how much?
104.
Then Dilip Das.
87.
Respondent number 3 is Dilip Das. Dilip Das. Dilip Das got 87. 87 and what is his roll number?
Philip Das roll number is 06FA 10871.
He got 27 in Bible, so according to this. Oh, it is 4 or 7. Okay, then R5. R5.
Hemanta Das.
Mosumi Das is respondent number 4. Dilip Das R3. And what is the next one?
Hemant Das.
Hemant Das.
This is not full. Dipankar is a dear one. We put on the government lecture. So much of legacy.
Hemant Das got how much?
98.5, 77 plus 1.5. Also assistant.
Amount of this. 98.5.
Madam, find out Hemant Das for me. Yes, Mr. Chutia, then what happened?
That one of the re-examination was done as per the honorable court's order.
Hmm.
Lordship, kindly see the order of this honorable court.
We have seen it. We have seen. Don't trouble yourself.
Yes,
Seen.
so they have examined it. The director alone cannot do it, my lord. He has a constitutional committee. The
Now,
committee
what do you how do you respond to Mr. Hazarika's contention that the rule says the selection has to be by the selection board?
selection.
But here the re-examination initially and after the court's order was done by the director, not by director and
committee,
by
my
his
lord,
hands,
that
whatever
committee.
it is by the director, not by the selection board.
But that is director constituted committee. Director can do it, my lord. Director
How? From where?
He alone he cannot do it, my lord.
No. He has to do it by the selection committee. The selection committee has not done it.
That is the, my lord, director said in the, my lord, affidavit, my lord. I have gone through it. The contest of the committee was constituted by the Director of Economic Statistics, Assam, Sport conducting the written examination. This committee was not termed and named as a selection committee as by the petitioner. And so, excluding the post of the director has authority to appoint the gate 3 post. It has authority to decision to constitute a committee. Our affidavit, Palo. As the interview sport competition of written examination for recruitment of the post because of the director alone cannot complete the Herculean activities relating to conduct of recruitment examination. Thus, constitution of a committee is not illegal as claimed by the petitioner. Moreover, the contention of the petitioner with regard to the selection, paragraph, I am reading paragraph 10.
Paragraph 10 of the affidavit.
Affidavit. Regard to the selection committee, moreover, the contention of the petitioner with regard to the selection committee that was constituted illegally to sit in judgment of the recommendation made by the selection board constituted under Rule 70 of the rule is not true, and it is totally denied. So it has explained it, Manu, how director has done it.
Actually, kindly interpreting page 79 of their activity. It's clear, madam. It is by the director, not by the board. There is no reference that the board, in terms of the board decision, that has been, they have been entrusted. Page 79.
79 is an affidavit advertisement.
No, well, page 79 of their affidavit, madam.
Page 79. Go to running page 9. Go to some.
5701. It was filed in 5701. Page 79.
5701.
What is that? Page 7, some marking problem is it?
No, madam.
What is that?
Page, our page. Running page at that moment.
Maybe, madam, this. this is
5,
an
oh, no,
ordering-
no, you are referring to that Jyotirmay.
Yes, madam. Page 79. This is an order passed by the director, Miller. May I read them? This is the 3rd of September 2014.
Will be denied.
In pursuance of this honorable court order, High Court judgment dated so against the petitioner so. Sri Purbojyotis Das, Senior Research Officer, and Sri Raman Kolitas,
Got it.
Statistical Officer. Of this director is hereby directed to jointly reevaluate.
Mr. Per contra, Mr. C.C. Chutia, learned senior counsel, additional senior government advocate, a senior counsel and additional senior government advocate, assisted by Miss L. Islam, learned counsel, appearing for the state respondents, submitted that an examination management committee was constituted for the conduct of the said examinations of the written examination in pursuance to the advertisements dated so and so and so and so, dated 8/8/2008 and 22/5/2009. Whoso. It is submitted by Mr. Chutia that after the conclusion of the said examination, the said management committee, examination management committee in its meeting held on 11/8/2010 had arrived at a decision to re-examine the answer script of the candidates appearing for selection to various posts, including the post of field assistant, who had secured 70 marks or above on a sample basis. He submits that the said revaluation in terms of the decision of the examination management committee was carried out for all the candidates who had secured 70 marks or more in the selection process. Whoso. Mr. Chutia submits that the written examination was conducted under the aegis of the Director of Economics and Statistics and was being monitored by the said examination management committee. Also, the selection committee as constituted in the matter in terms of the provisions of Rule 17 of the Rules of 1980 had conducted the viva voce segment of the selection process and thereafter the marks secured by the candidates were added to the viva voce secured in the written examination were added to the marks secured by each of them in the viva voce segment, and accordingly the final list of candidates was so prepared on merits. Whoso. He submits that in view of the appointments effected on compassionate grounds, the initially advertised number of the 43 posts of field assistant as initially advertised, while the said advertisement stood reduced to 37 posts, and accordingly the said posts were so assigned to various reserved unreserved communities. Also, he submits that the selection committee as constituted in the matter had thereafter prepared a select list of 37 candidates for 37 numbers of posts now available for recruitment. And accordingly, the said list was published in the daily newspaper Assam Tribune. Also, Mr. Chutia has further submitted that although, next item, although there was anomalies found, although it was found that the names of the names of the respondent number 3, 4, and 5 were dropped from the list of candidates found successful in the written examination, comma, subsequently, although oh, there was only a corrigan of the subsequent, however, a corrigendum was only issued in respect of the respondent number 4 and not in respect of the respondents number 3 and 5. He, however, has clarified that the respondents number 3 and 5 being found to have secured marks in the written examination within the cutoff marks so prescribed for their respective categories, comma, and the detection in respect of the anomaly occasioning with and the detection of the anomaly occasioning in respect of the respondent number 3 and 4, 5, having been so detected at a much delayed state, comma, without issuance of a corrigendum, comma, the said two candidates were permitted to appear in the viva voce selection. By referring to the final list of candidates prepared by the selection committee, Mr. Hemontodas, roll number?
Roll number 07F8342.
Now he is said to be absent here. How was he appointed?
Hamonto Das, roll number 342. Will drop.
Report.
That's removing one. Will drop.
Hemontodas is absent.
Will
What
drop.
was he appointed? Huh? What was the cutoff for SC category? What is the cutoff for SC category?
Double.
I don't. SC category, but.
Because he was original.
Anyway, you are not interested with SC.
No, only because they are not successful in the written test, I am challenging their effort.
You are not interested with SC. Absent.
That is my specific allegation.
Anyway, if we interfere with his appointment also, you are not going to get it.
Okay.
That was the SC post only. How? Appointed then. What is the cutoff for SC? Oh, so. Respond number 3 is?
3 is Melota. Yes, sir.
OBC.
MOBC. Delete that. Your lordship will find at base 24. The final selected.
And Mosumi does is OBC.
Obviously.
So it is only Osim Burman who can get a post, either of them. Osim Burman comes up. Jyotirmoy still will not come. He's a general. Lahat. Mr. Chutia has further submitted that while the respondent number 3 herein is a candidate belonging to the MOBC category, comma, respondent number 4 belongs to the OBC category. He submits that the respondent number 5 belongs to the SC category, and accordingly, the petitioners herein who belong to the OBC and the general category would cannot assail the selection and appointment of the respondent number 5. He submits that it is only the petitioner in petition number 5693/2014 who would be who can present a challenge to the recruitment of respondent number 3 and 4, inasmuch as he belongs to the OBC community, while the petitioner in WPC number 5701/2014 would not be cannot present a challenge to the recruitment of the respondent number 3 and 4, inasmuch as he belongs to the general community. Yes, Mr. How can you challenge today?
With respect to Zucchini, my beloved, the minimum marks secured by the selected is
You have not made him a party. Have you made him a party? The general category candidate. You have not made him a party.
in the first round. They were.
You second round. Now, how can I go back to first round? That was by my guru. I'm a chela now. I can't. Okay. Anything more, Mr. Chutia?
Nothing.
Nothing. First up, in view of the above, in the above premises, Mr. Chutia submits that the subsequent re-examination being made. Mr. Chutia further submits that this court, having remanded the matter back, specifically directing the Director of Economics and Statistics to re-examine the case of the petitioners in the above noted two petitions, the petition without any further stipulation as to the manner in which such examination is to be conducted, the respondent number 2 having carried out the process of re-examination and in respect of the petitioner in WPC number 5701/2014, it was found that he had actually scored 75 marks in the written examination and not 80, as not 79.5, as was marked to him in the earlier round of examination. He submits that while there was a decrease in the marks scored by the respondent number, by the petitioner in WPC number 5701/2014, in respect of the petitioner, WPC number 5693/2014, it was found that on such a revaluation, he was marked 77.5, whereas in the earlier round of examination, he was marked as 76. Accordingly, there was an increase in the marks secured by the petitioner in WPC number 5693/2014. Mr. Chutia submits that going by totaling the marks scored by the petitioners in the above noted petition in their written examination, along with the marks scored by them in the viva, the petitioners have found to have not secured the cutoff marks as obtaining in the said selection process for the categories against which they had submitted their respective candidates. In the above premises, Mr. Chutia submits that the present petition would not, the claims made by the petitioner in the present petition would not mandate an acceptance. Yes, Ms. Chaudhary. Anything more you will adopt? Ms. K.K. Chaudhary, Learned Counsel for the respondent number 3, 4, and 5. Submits that she would adopt the submissions made by Mr. T.C. Chutia, Learned Counsel, Learned Senior Counsel, and additional senior government advocate appearing for the state respondents. I have heard the Learned Counsel for the parties and perused the materials available on record. Ekini, Maidi. Heard the Learned Counsel for the parties at length. Hearing concluded, registry to list this matter again on Friday for delivery of orders.
Fine. No place.
Nothing more to be added?
No, my lord. Even my lord, if your lordship is found that he was absent in the interview, my lord, that.
But if he has scored that there is no challenge, you can't challenge him. I'll take that route. Can't help it. We'll give it a closure. 2014 matter, we are giving it a
It
closure.
shows that there is.
There may be, but it's too late in the day.
Lordship. It was file
Obliged
immediate.
for that.
Huh? Luck.
Luck. Obliged.
Yes. Yes.
Other than missing content matters.
Huh. I've heard the matter, I've forgotten the matter, everything is up.
The petitioner.
Just give me a book.
The petitioner will also having a
The departmental candidates, that qualification, whether that can be treated as 3 years in. Yes, Mr. Cho.
In fact, my Lordship, the diploma given by the College of Military Engineering,
Hmm.
that is his primary case.
Hmm.
That is recognized.
Hmm.
By
By
the-
AICT also.
If I may take your Lordship to page 55 of my affidavit.
Hmm. Hmm.
There's a notification and and subsequently, Lordship, there were further notifications in 2012 and 2012.
Hmm.
So as it is, Lordship, the primary contention of the petitioner that the diploma given by the CME
Hmm.
cannot be acted upon,
Hmm.
that goes, Lordship. And in any case, Lordship, if he has to challenge, if he has to put the challenge
To the
To-
rules.
to the diploma
Hmm.
given by the CME, those candidates are not before your Lordship. That would be my primary stand, Lordship. And in fact, in one of the cases before this honorable court, I'll give a copy, Lordship. It is in WPC 2763 of 14. Wherein before a division bench,
Hmm.
give me a second. My friend was there.
He is the expert.
He is the in the same case also, towards the end, if the prayer of inter se seniority between these two groups, that is the CME and the are to be decided, the same may have an impact on the inter se seniority of these employees having diploma from the College of Military Engineering. There is no dispute to the fact that the diploma holders from the College of Military Engineering have been conferred the benefit of promotion to the higher posts during the period 1986 onwards. And some of them were accorded seniority over the petitioners. In their absence, if any direction is issued for fixation of seniority, it is likely to jeopardize the interests of these employees.
Yeah, in this case, the seniority was correct. Because
Here,
they were party.
here it would be the
In this case,
qualification.
In this case, I am not challenging their seniority.
It
I
would,
am praying for preparing a separate graduation list in respect of the persons who were 3 years diploma holders
Hmm.
and those persons obtained diploma from the CME.
Hmm.
Because CME is not approved by the NCT.
No, there was an AICT
Yes.
somewhere I found. Where is that? AICT had somehow granted this.
But it is only in the website they have.
Come to page
Page
8,
58.
internal page 8 of the affidavit filed by Mr. Chaudhary.
that is paragraph 9, Lordship.
Paragraph 9. Page 8, end of the first paragraph there. Yes, Mr. Choike, anything more? Second affidavit.
Hmm?
Your case is that this is not recognized by AICT. Now they show that this is recognized by AICT. Secondly, this provision is there in the rules. Now, if I have to say that there has to be a separate seniority list, I would be touching on the rules, which I sitting singly I cannot. And there is no challenge to the rules. Nothing more is to be done. Very close.
Please, Vinod.
I'll pass the orders. Don't, second half I'll pass the orders. Yes, where is the division bench order?
Lordship filed.
The respondent has given a go by. Respondents have given a go by. They have, they are not contesting. Now what is left?
There are 104 is governed.
I have read it. Beautifully written.
Lordship.
We'll have to remand back the matter.
Paragraph 104, Lordship.
Ms. Fukan, you are appearing for the government. You have given up on this challenge. You are agreeing. So they are not interested to contest. Or this court should wait. If they want to come, they can come. Otherwise, we'll follow this. Part of consolation between them. Oh. Yes, make your submissions.
Lordship, I am relying on the
Yes, they are not contesting. We will allow it.
Lordship.
Yes,
In the light of the division.
this
results,
decision you
Lordship,
want me to cover up that.
Lordship. Only that, Lordship, paragraph 104 covered up my case, Lordship.
Yes, okay. But Mr. K. A. Mojumdar, Learned Counsel for the petition.
Lordship, can this matter be taken after some time?
I'm sorry, no.
Lordship, Mr. P. Nayak will assist this court. His legs on court 10, Lordship.
But there was none here when the matter, we were here for 5 minutes, 10 minutes.
Lordship,
Do you
we
think that this court is having no other
no,
work?
no,
Eh?
Lordship. No, Lordship. Just
There is no representation for 10 minutes in such a matter. I'll have to pass the orders. Why should I wait?
my apology.
If you're not
Lordship.
interested to even come make a mention, we waited for 3 minutes, not done, kids.
No,
Why should we wait?
my
Madam, we are not
apology.
interested. We'll presume that we'll say that nobody was there. Face the music.
Lordship, just after some time, Lordship.
Yes, what is your case?
Lordship, petitioner is joined as a master of Lordship on 8/4/1976, Lordship. And repeatedly is all
Why
the
was your case dropped in the last round?
Lordship, they have stated in the affidavit, Lordship, page 53. Lordship, they have stated that the petition, last line, Lordship, the petitioner will be regularized on receipt of the approval from the government, Lordship. In 2007, Lordship, or my junior also regularized, Lordship, but the petitioner has deprived. And now he is retired, Lordship. He is retired on 0/1/2017, Lordship.
Retired on?
1/2/2017, Lordship. I have annexed also that copy also Coronation, Lordship. Page 60, Lordship. I'm filing my additional affidavit.
This is item number 6.
6, Lordship.
Respond number 8 is your junior. That's why you have made him a party. He was
Lordship,
provincial.
lordship. Already, yes, I am not against him lordship. I should have to get lordship because I'm not getting nothing lordship.
Hmm.
I already retired.
So
lordship.
you were recruited, you were appointed sometime in?
Appointed on 8/4/1976, lordship. I have annexed the copy of my, all reports are also there, lordship. Their report is also there.
Hmm.
And my case was forwarded, lordship.
Your case was forwarded in 2005.
Lordship. In 2007, lordship,
Hmm.
my case was forwarded.
Hmm. Hmm.
In 2005, I was transferred lordship to Koringal. Then lordship, sorry,
Hmm.
on 2/6/2007, lordship,
Hmm.
page 27, my name was forwarded, but they have made some that date of engagement not furnished, saying that. But subsequently,
Hmm.
again, they mentioned page 31, pro forma. It
Page?
was submitted by 32 with the original copy, type copy is page 31, lordship. Mokaddas Ali, date of joining, lordship, 8/4/1976.
Annexure,
again-
annexure.
Lordship, annexure F. And D plus. Then also G, annexure G also page 33.
Annexure with reference to the inform you that the information was submitted by this office. This is after the earlier round of regularization.
Lordship.
Where is your name?
My name is serial number 4, Lordship Mokaddas Ali. Sorry, that one. And in page 33, Lordship, my name is serial number 3, Mokaddas Ali.
Serial number?
Serial number 3, Lordship, page 33, annexure G.
33. Serial number?
Serial number 3, Lordship,
Mokaddas Ali.
Mokaddas Ali, still working, there's it. It was submitted by the executive engineer on 12/12/2008, Lordship. Then again on 1/11/2014, my name was referred page 37.
Yes, got it.
And their affidavit also they have admitted.
They have admitted to that.
Lordship.
Hmm.
And I am relying on the apex court as well as the dishonorable court judgment, Lordship.
Which paragraph do you want to rely upon?
I am relying, Lordship, paragraph 1042, Lordship, 212.
Hmm. Hmm. Hmm.
I pray, Lordship, that let the authority may consider my case, Lordship, for regulation and all other pensionary benefit like others, Lordship. This is my respectful submission before your Lordship.
Okay. Yes, Mr. Soike. Your item is?
You can do judgment is needed for Lordship. I also, can I supply the copy of Sukendu's judgment, Lordship? Sukendu, but
No, I haven't. Sunil Kumar Roy.
item number 16.
Let us see 15 first.
Item number 15, my lord. Some of the petitioners are
How many
appointed.
petitioners are there?
My lord, here, my
one,
lord,
15?
34 petitioners are there, but my lord, all of them are not covered by Sugandhu Bhattacharjee, my lord.
No, serial number 7, how many are there? Serial, you are not in serial number 7. Who is for serial number 7?
Worship, I appear for the BTC in item, I appear for BTC in item 7.
7.
Yes.
Okay.
Also, item 27, Lordship, is a BTC matter, similar. case.
I am for 7.
7, yes, what is your?
My appointment was, my lord, 1/2/1993, my lord. Covered by Sukhendu De. Sukhendu.
Your appointment was of?
1/2/1973. 93.
First February 19.
And
Any affidavit filed?
Yes,
One for
we filed
1990.
What is your stand in the affidavit?
Lordship, two submissions. One, Lordship, there was a OM of 20 March 2015, wherein he was serving as a sweeper. So such posts were directed to be specifically outsourced. So that is one stand we had taken.
That is still 2000 from 2015,
Yes,
but he is working
since
from
90.
93,
Yes.
2005
Now.
circular covers his case.
Yes, it
Sukhendu
covers.
Bhattacharjee will cover his case.
It will cover his case, Lordship. And also secondly, one aspect, Lordship, we have forwarded his name in 2014
But,
to
but
WPTP.
you are supporting.
Yes, Lord. We will remand it subject to the factual verification, Lordship.
Done.
My lord, Lordship will hear the other side, so far as the state part is
No,
concerned.
we will hear today because
So
Mr.
today itself,
Gogoi-
we are not praying for.
Mr. Gogoi, what has happened? The petitioners are waiting. This court was waiting for nearly 5 to 7 minutes that somebody will come. I asked everybody.
My lord,
Nobody responded. What should we do? What should we do?
I understand. I apologize for that, my lord. He's on election port 10, my lord. And my lord, so
We
far as
have got,
Sukhendu,
no, if somebody makes a mention, we are
I
ready.
understand.
But
Could be, my
we
lord.
cannot presume something, no?
Yes, yes.
Can we?
Court,
Or should we presume?
No, I apologize for that, my lord. And regarding Sukhendu, my lord, there is a new recent development, my lord, of the Honorable Supreme Court itself, that, my lord, that judgment is not a precedent. This on the Honorable
Nazma
Supreme-
Khatun.
Yes, we'll play.
Nazma Khatun will not have any application in this cases. It says that it is in the facts of that case. This case is connected to Sukhendu Bhattacharjee.
But that lordship will consider, my lord, only part, my lord, his part may be considered after some time. Within item number 1, my lord, in court 10, he will be here. After some time, my lord. Our part, my lord, lordship has heard their part.
We have heard there is nothing more to hear from.
Yes, that's why so far as the state part is concerned, he will, my lord, otherwise he's prepared and he's there for this particular case.
Ma'am,
I understand.
can
I
wait.
apologize
I'm
for
here
that,
Till
my lord.
4:30, I have no objection. Till date, I have not.
I understand, my lord.
But if there is total empty, nobody is
Right.
bothered. I ask them, whomever,
I-
you can see the video.
I understand, my lord. He will be here, my lord, immediately. Only on his part, my lord. Whatever
Item
lordship
number
pass,
6, 7, 10, 11, 15, 16, 17, 18, 19, 23, 24, 25, 26,
27.
27, 31, 32, 33. Etu, mock whatever. Yes,
So-
next. We'll hear the matter. Don't worry.
Yes, today itself it will be, my lord, complete.
Hmm.
I'm like,
Mr. Gogoi, we have got no issue in
no, I understand.
accommodating.
That's
applicants.
why
We
I'm
know.
apologizing, my lord,
But
probably,
thing is, if there is none present
yes,
and nobody to make a mention, why should I wait?
no, I understand.
Yeah. Thanks. Hello. Yes.
Person has asked me to prepare the list of the, but I contacted with the petitioners also, but they also could not help me and perhaps all the petitioners are the fixed and casual.
So it's already covered. You are
Yes.
not going to get
Yes,
anything.
yes.
We'll close it.
Lordship, with my senior presence, because I'm not in this matter also. That's the difficult.
We have been accommodating you for a long time.
Yes, Lordship.
Call Mr. Monto Wilson.
Yes, yes.
Kindly pass over this matter for time.
10 একে এইটো আগৰ যাব এইটো regularization 10 11 we'll take it up after some time.
Please, Your Lordship, can you take the matter, kindly can you take the matter afterwards? My counsel is in.
I've grown old, maybe I'm not hearing.
My lord, can you please kindly take up the matter afterwards? My senior is on that.
Time being,
Yes, sir.
done. This is can you listen?
Lordship, I'm appearing for Miss M.
Huh?
I'm appearing on behalf of Miss M. Das. She is on legs in court number 4.
She was not here yesterday. We have already passed the order. We are just to conclude it.
She will be appearing.
Huh?
She's coming.
It was you, not nobody you had represented yesterday. You have already passed the orders.
Lordship, I was informed.
Huh?
I was informed today morning.
Not interested. There was. Okay, all of them. Okay, all of পিছত মাতিব ডেলিভারি কথা কি হাজারিকার ফাইল heard Ms. U. Das, learned counsel for the petitioner. Also heard Mr. S.P. Chaudhary, learned CGC, appearing for the respondents. The petitioner in the present writ petition has prayed for a direction upon the respondent authorities to treat her husband to have died in harness on 31/3/2009 and thereby and on such consideration and on such a reckoning to authorize to the petitioner family pension and other retired benefits of in connection with the services rendered by her husband. So, the facts in brief requisite for adjudication of the writ petition is noticed as under. The husband of the petitioner, Manbir Thapa, was enrolled as a rifleman, GB, general duty, on 15/8/1992 in the Assam Rifles and was posted to the 22nd Assam Rifles. The husband of the petitioner on 26/11/2003 was sent on extra regimental employment duty to the Assam Rifles Training Center and School. The husband of the petitioner was continued therein till 7/2/2007 when he was reverted back to his original unit, that is 22nd Assam Rifles. Also, it is projected that after the reversion of the husband of the petitioner to his original unit, he had gone missing. And the petitioner, and the petitioner, in spite of making all efforts, could not gather any information with regards to the whereabouts of her husband. It is further projected that after long lapse of time, her husband had reached home with the help of an unknown person, and he was in a very bad mental health condition. So, it is projected that the petitioner thereafter provided the medical attention to her husband. However, in spite of the best efforts of the petitioner, the health condition of the husband, her husband deteriorated and he passed on, on 31/3/2009, succumbing to his ailments. It is projected that thereafter the petitioner had applied for family pension. It is projected that the petitioner had informed about the demise of her husband to the authorities of the unit of wherein the husband of the petitioner had served. The petitioner projects that she was thereafter given the requisite forms for applying for authorization of family pension to her. The petitioner accordingly submitted the requisite application forms and also an application praying for consideration of her case for appointment on compassionate grounds. It is projected that the matter was processed by the respondent authorities. However, via the communication dated 17/3/2011, it was intimated that as the husband of the petitioner was declared as a deserter with effect from 8/2/2007, he not being in service on the date of his active service on the date of his death, the petitioner would not be entitled to any pension and pensionary benefits. The application submitted by the petitioner for appointment on compassionate grounds was also rejected on the ground that there was no vacancy available at the relevant point of time. The petitioner further projects that although the intimation with regard to the demise of her husband was given to the respondent authorities, the commandant of the 22nd Assam Rifles Battalion, via an order dated 25/3/2012, proceeded to impose the penalty of dismissal upon the husband of the petitioner on the ground that after being declared a deserter, he had not resumed his services for a period of more than 5 years. The claim of the petitioner for being authorized pension and family pension and other pensionary benefits having been rejected, and the petitioner only being given terminal benefits, the petitioner has instituted the present writ petition. Ms. Yudas, learned counsel for the petitioner, after reiterating the facts noticed herein above, has submitted that the declaration of the declaration of the husband of the petitioner to be a deserter by the court of inquiry as convened in the matter did not have the effect of terminating the service of the petitioner's husband. She submits that the petitioner's husband continued to remain in service and the employer-employee relationship with the respondents continued to be maintained by him in the matter. She submits that the petitioner's husband, being on account of the medical ailments suffered by him, was not in a position to resume his services and was constantly under medical treatment. She submits that had the condition of her husband improved, medical condition of her husband improved, he would have surely resumed his services. However, before the health condition of, however, she submits that the husband of the petitioner passed on, on 31/3/2009. Ms. Udas submits that after the death of the husband of the petitioner, the petitioner had duly intimated the respondent authorities of the said fact and had prayed for being authorized her family pension. She submits that only on the ground that the husband of the petitioner was on being declared a deserter, was held to be not in service, the petitioner was denied her family pension and other pensionary benefits, although the case of the petitioner was duly covered by the provisions of Rule 54 of the Central Civil Services pension over Rules 1972. She submits that the services of the husband of the petitioner not having been terminated, the respondent authorities could not have denied to the petitioner her due family pension and other pension and pensionary benefits. Also, in the above premises, Ms. Das submits that this court would deem the petitioner's husband to have died in harness and accordingly direct the respondent authorities to authorize to the petitioner her due family pension and pensionary benefits on account of the services rendered by her husband. Per contra, Mr. S.P. Chaudhary has some Mr. S.P. Chaudhary, learned CGC, appearing for the respondent authorities, have submitted that the fact that the husband of the petitioner had passed on, was duly intimated by the petitioner to the respondent authorities. However, on account of a communication gap, the commandant of the unit wherein the petitioner's husband was last posted, proceeded to issue an order dated 25/3/2012, imposing the penalty of dismissal from service upon the husband of the petitioner. He submits that the said order dated 25/3/2012, having been issued after the death of the husband of the petitioner had so occasioned, would have no significance and the same is to be ignored. Also, Mr. Chaudhary submits that the husband of the petitioner, after being repatriated to his original unit, reverted back to his original unit from the Assam Rifles Training Center and School on 7/2/2007, had remained unauthorizedly absent and his whereabouts were not known. Also, accordingly, he submits that an apprehension roll was issued by the authorities of the unit of the petitioner on 25/8/2007 to the jurisdictional district magistrate and the superintendent of police of the native district of the husband of the petitioner with a request to apprehend him. He submits that a copy thereof was also forwarded to the petitioner hearing. However, he submits that the husband of the petitioner could not be apprehended. Mr. Chaudhary has further submitted that the petitioner hearing had also not responded to the apprehension rule as sent to her by the unit of her husband. So the above being the Mr. Chaudhary submits that in the above in the said fact situation, comma, a court of inquiry was convened under the provisions of section 106 of the Army Act to inquire into the circumstances under which the husband of the petitioner continued to remain absent from his duties. He submits that the court of inquiry on examination of the materials available on record, comma, and by following the due process, comma, arrived at a decision to declare the petitioner's husband as a deserter with effect from 8/2/2007. Accordingly, he submits that the name of the petitioner, husband of the petitioner, was struck off from the unit strength. However, he was kept on supernumerary strength for 5 years as per the policy. He submits that the deserter continues to maintain a lien in his service for 5 years after desertion. Next, Mr. Chaudhary has further submitted that on the intimation being given by the petitioner about the demise of her husband, comma, process was initiated for grant of family pension to the petitioner hearing. However, subsequently on noticing that the petitioner continued to remain as a deserter from service even at the time of his death, comma, the petitioner's husband not being found to be in active service on the date of his death, comma, the petitioner was held to be not eligible under the provisions of Rule 54 of the CCS Pension Rules 1972 for being authorized pension, family pension, and other pensionary benefits. He submits that the petitioner was, however, authorized all other terminal gratuity terminal benefits as was admissible under the rules holding the field. So, in the above premises, Mr. Chaudhary submits that the claim made by the petitioner hearing to deem her husband to have died in harness and accordingly to process the family pension and other pensionary benefits and to authorize to her family pension and other pensionary benefits would not mandate an acceptance from this court. I have heard the learned counsel for the parties and also perused the materials available on record. From the pleadings brought on record as well as the rival submissions of the learned counsel for the parties, the following question arises for determination by this court in the present petition. A1, whether the finding of the court of inquiry declaring the petitioner's husband as a deserter, comma, by itself and without more, comma, would disentitle the petitioner to family pension under Rule 54 of the CCS Pension Rules 1972. More particularly when subsequently the death of the petitioner was asserted. 2. CCS rules to rule Mr. We'll give Chaudhary, Mr. Roy, This will take some time because I'll be rising today at 12:45. We'll sit a bit late. Anything is there, the second half we'll take it up.
Well, in case I'm engaged in an amendment.
You can
and
come
we'll
back. All are
have
engaged today.
29 or 30.
Today I stopped, I'm dictating. I wanted to dictate in the second half, but nobody was there. What should I do?
Yes.
So I started
Yes, yes.
dictating.
Yes,
Every case adjourned,
Yes.
time being. So I better dictate my orders.
Yes.
That's all. Second
We
half
are
we'll
obliged.
take it. We'll take up in the second half. If you are there, you come. Otherwise, you make a mention. Also, the husband of the petitioner, having not reported for his duties in his unit, that is the 22nd Assam Rifles, after being reverted from the Assam Rifles Training Center and School on 7/2/2007, an apprehension roll was admittedly issued for apprehending the husband of the petitioner by his unit authorities. The husband of the petitioner, however, not being apprehended and he not having reported back for duties to his unit, a court of inquiry is found to have been convened invoking the provisions of Section 106 of the Army Act. The said court of inquiry, upon following the procedure mandated, had arrived at a decision to declare the husband of the petitioner as a deserter with effect from 8/2/2007. Also, the husband of the petitioner, on being declared a deserter, his name being struck off from the unit string, the respondent authorities had deemed that the husband of the petitioner was not in active service on the date of his death, and accordingly the petitioner was held to be not covered by the provisions of Rule 54 of the Rules of 1972. Rule 54 of the Rules of 1972 provides for grant of family pension to the family of a government servant, who dies, whether before or after retirement. The said rule is a beneficial provision, its object being to provide a measure of financial security to the family of a deceased employee. It is well settled that provisions of this nature must be interpreted liberally and in a manner that advances, rather than defeats, their welfare object. In the case on hand, it is not disputed that the husband of the petitioner had passed on, on 31/3/2009. In the normal course of things, the petitioner would have been entitled to family pension under the provisions of section of Rule 54 of the said Rules of 1972. However, the respondent authorities, in view of the fact that the husband of the petitioner was declared a deserter with effect from 8/2/2007, had held that the husband of the petitioner not being in active service on the date of his death, the petitioner would not be entitled to pension, family pension, to be authorized family pension and other pensionary benefits on account of the services rendered by her deceased husband. Also, the respondents in the present writ petition has not brought on record any material to demonstrate that after the husband of the petitioner was declared a declared a deserter, proceedings were instituted against him for having committed a misconduct of remaining unauthorizedly absent, and orders were passed thereon. Also, although the husband of the petitioner was only declared as, although the husband of the petitioner was declared as a deserter, he continued to remain, he continued to be born in this service, however, against a supernumerary strength of the unit. There being no order of dismissal or removal issued against the petitioner, petitioner's husband during his lifetime, the employer relationship between the husband of the petitioner and the authorities of the Assam Rifles cannot be deemed to have ceased to exist prior to 31/12/2009. The finding that the conclusion reached by the court of inquiry that the petitioner's husband was a deserter, at best, may be a ground for proceeding against, would have been a ground for proceeding against him for having remained unauthorizedly absent, and for the purpose of forfeiture of his pay and allowances for the period he had so remained unauthorizedly absent. However, the said order of desertion, the declaration of the husband of the petitioner to be a deserter, in the considered view of this court, given the continuance in service of the husband of the petitioner till the date of his death, would not operate as a bar for authorizing to the petitioner, her family, pension and other pensionary benefits. Also, in view of the above discussion, this court is of the considered view that only on issuance or on declaration of a force member to be a deserter, by itself would not also mean that the said force member was terminated from his services by way of an deemed order of dismissal or removal, thereby disentitling his family members from being authorized family pension and other pensionary benefits. In the case on hand, it is an admitted position that the husband of the petitioner had passed on, on 31/3/2009. That is within a period of 2 years from the date he was declared to be a deserter. The 5-year period as projected by the respondent authorities had also not been completed as on the date of death of the husband of the petitioner. Also, accordingly, this court holds that only on account of the fact that the husband of the petitioner was declared to be a deserter, there being no order of dismissal or removal passed against the husband of the petitioner during his lifetime, that is on or before 31/3/2009, the petitioner cannot be denied her due family pension and other pensionary benefits. Having drawn the said conclusion, this court would now consider as to the manner in which the period of absence of the husband of the petitioner with effect from 8/2/2007 till the date of his death, that is on 31/3/2009, is now to be reckoned. Also, it is an admitted position that after that with effect from 8/2/2007, the husband of the petitioner had not reported for duties. From the materials brought on record in the petition, this court finds that the husband of the petitioner, on account of psychiatric disorder and other health ailments suffered by him, was under treatment at various institutions. Also, finally, the husband of the petitioner is found to have succumbed to his such ailments. Also, the certificates produced by the petition, and annexed to the petition, having not been considered by the respondent authorities, this court also, the respondent authorities have not had the opportunity of examining the veracity of the claim made by the petitioner in the present petition about the nature of the ailment suffered by her husband. Also, however, the documents brought on record go to reveal that there was a justifiable reason on the part of the husband of the petitioner for having remained unauthorizedly absent. The absence of the husband of the petitioner is found by this court to have so occasioned for reasons beyond his control. Also, however, finding that the husband of the petitioner had not rendered services with effect from 8/2/2007 till 31/3/2009, this court would not proceed to direct the respondent authorities to authorize to release the salaries of the husband of the husband of the petitioner for the said period. However, the salary of the petitioner, the said period would be required to be so reckoned for the purpose of determining the quantum of family pension and other pensionary benefits to be authorized to the petition hearing. Also, for the said accordingly, the respondent authorities are directed to fix the pay of the petitioner, of the husband of the petitioner as on 31/3/2009 by notionally fixing his pay with effect from 7/2/2007 and thereafter to basing on the pay now determined in respect of the husband of the petitioner as on 31/3/2009, the respondent authorities are directed to process the family pension and other pensionary benefits claim of the petitioner and to release the same to her. To process the family pension proposal in respect of the petitioner and on finalization of the same to release to the petitioner her family pension with effect from 1/4/2009. The petitioner shall also be entitled to be authorized other pensionary benefits as admissible in law. on account of the services rendered by her husband. The areas of the family pension, along with the other pensionary benefits admissible to the petitioner, be released to her within a period of 3 months from the date of receipt of a certified copy of this order. Considering the long lapse of time occasioning in the since the date of death of the husband of the petitioner, the further prayer made by the petitioner for consideration of the case of one of her sons for appointment on compassionate grounds against a compost commensurating to their educational qualification, however, stands rejected. Also, the respondent authorities to process the matter accordingly in terms of the directions passed herein above and authorized to the petitioner her due family pension and pensionary benefits within the time frame mentioned here in above. With the above observations and directions, the present petition stands disposed of.
So item in respect of item number 8. So may I can take it on Thursday, 20.
Thursday, I'm sorry.
Because Mr. Mahanta is on legs before a court number 1 in the second half. Matter is
Monday, Thursday, we have fixed up a lot of stuff.
there's some other.
But the learned counsel for the parties. The petitioner, learned counsel for the petitioner was granted time on several occasions to prepare a list wherein the benefits are receivable by the benefits areas, the benefits, VRS benefits are receivable by the petitioners were to be highlighted.
Yes.
However, the learned counsel for the petitioner has submitted that the said list was not permissible or could not be prepared as the petitioners were also not in a position to provide the requisite inputs. Also, in view of the above, the matter stands accordingly, the petitioner, learned counsel for the petitioner further prays that he be granted further time for submission of the said list and or to make final submissions in the matter. Also, in view of the above position, the registry to list this matter again on
27.
27
Okay.
8/2026. No further hearing, no further adjournment shall be granted in the matter. Yes,
She was supposed to pass.
I'm passing it. I have passed one, pass the second one.
Possibly your lordship permits me, I have a matter in the law court.
Mr. Bhaumik, you need not be here. With the other case also, I told you, this is orders. I've heard you. Only thing I'll record you on. And Mr. B.D. Das was very fair.
Aye.
I'll have to deal only with 2 contentions office. I'll do that and I'll dismiss the
There is no quid pro quo.
not quid pro quo. And one more I'll add, just to give it a semblance of something, that you had required that Rinku to be brought in,
Here.
but it was denied. I'll say that I have paid. Yes. Yes.
Item number 28.
Require some time to
Why?
order it.
We had given you nearly a month.
Lordship, yes, but Lordship, the order, there was some delay in uploading the order. So,
It was
no,
uploaded.
online when I was looking in the mobile, so it was not there.
No.
In the kiosks, it was there. That was, but till
It
yes,
uploaded this also. Huh? Nothing.
okay.
File to some.
So maybe in the mobile, there was some.
I'll just check
yes.
when it was approved.
Because yesterday afternoon also, when I was looking at the mobile, the order was not there. Mobile.
Hey, 28/7. Moirik could have kitty upload to it. You are having no idea. It 28/7 or. Inna place. Law paine kitty upload to it. Give me 10 minutes, we'll just have it confirmed.
Right.
Yeah. Who is appearing for the,
My lord, the health department, my lord, on the last time Mr. Dipankar Bora appeared. My lord.
this matter was listed before?
No, my lord, and another neat matter, my lord, my senior friend appeared. My lord.
A2, like who doesn't be reasoning. This is the uploading. No, it was a,
In the mobile,
we can't help it.
maybe there was.
We can't help that, madam.
Because we have also got the printout from the thing.
This is the uploading.
Lordship, maybe because
That you
yesterday
take up with
also-
the authorities. That cannot be a ground.
Lordship, give me some time, Lordship, 2 weeks time, Father, to produce the records. So
No,
because
the ground that you have taken is,
Lordship, I have checked in my mobile, maybe there was some internet problem, maybe, Lordship.
when,
So there-
tomorrow,
Lordship,
Monday.
2 weeks, Lordship.
We will forget the matter.
Okay, Lordship, next month.
Next Friday. Next Friday. Miss, on the prayer of Miss L. Devi, Learned Counsel appearing for the respondent number one. Respondent number 1. I filed today.
Yes, no, yes.
Respondent number 1, comma, further time till 28/8/2026 is granted for production of the records as called for by this court wide the order dated
My lord, 28/7.
28/7/2026. Also, in the event the records are not so produced, comma, this court would proceed to draw adequate, appropriate presumption thereof. Appropriate presumption thereon and proceed with the hearing of the matter. We'll draw our presumptions and we'll proceed. We'll draw a presumption that you have not determined the eligibility criteria.
No, Lordship.
Last time the lordships kept this matter on top of the admission matter, my lord.
Ah.
Is it possible, my lord?
It'll come, you just make a, Mr. Kapil, make a mention.
My-
Madam, you just, now you know.
Lordship,
Now you know.
maybe there was, no, I was not discussing the code, but
No, no,
maybe
no,
there
no.
was some,
Not discussing it. It's because I know that it was uploaded, because I personally saw to that it was uploaded.
no, even I took up with the court master also that today I saw that it is, but maybe due to some
Okay, no
technical
problem.
problem, Lordship.
You had some problem, but next time, please ensure.
I'm sorry,
No, no,
but I
it's
don't
nothing to be
discuss the
sorry.
code, Lordship.
You just get your instructions.
Yes, Lordship, I'll try to.
Get somebody.
My lord.
Today, I don't know why no matters are being permitted to be taken.
My lord.
If that is so, I'll sit and dictate judgments. That is better. Come on. Mr. Bhuyan, get somebody.
My lord, I'm calling.
Is your lordship?
Hmm.
My lord, the disciplinary authority predetermined. Dismissed me. The discipline is not as per law, my lord. So I am giving no chance to defend. I have no chance to the witness, to cross-examine the witness. My lord, the order also contrary to my law.
Where is
Well,
the charge sheet?
The disciplinary predetermined do not.
You have already said predetermined. Show me the charge sheet.
My lord, kindly see page 46, my lord. Page 46. Point 46 is the so-called notice. Last para, my lord. your written statement stating whether you desire to be heard in person should be submitted to the underside within the period specified above. You will be allowed to present your case if you desire with assistance or any other government servant approved by the disciplinary authority, but you will not be allowed to engage a legal practitioner for the purpose unless the person is nominated by the disciplinary authority. My lord, my lord, my lord, kindly see the page, page 60, 60, 60, 60, 65 minor. It is the reply of RTI minor. RTI. After last part, however, the copy of Honorable High Court to reinstate the ex-constable 6 is Lavendra Sarkar not found. I filed RTI regarding the reinstate order of Honorable Gauhati High Court regarding.
Where is that order?
No order.
No, what is the case?
But it is reflected in the.
What is the case number?
Huh?
Case number. Writ petition number.
No writ petition number. My lord, it is reflected in the order, my lord. Page
You don't
60.
know how can it be? You filed the case. That is why you were in.
Page 60, my lord. Page 60. Page 60, it is reflected. The dismissal order. Why it is destroying the violating, neglecting the Honorable Gauhati High Court order. It is not.
Yes, Mr.
Page 60, my lord. Kindly see para. It is my RTI
That is
application,
an
my lord.
earlier round, not
Huh?
this. Earlier. Yes, Mr. Goswami, what is your case?
Lordship. First of all, 2011 removal, Lordship. Now it is 26, Lordship. The matter was filed on 25, Lordship. The writ petition was filed on 25, Lordship. The removal 2011, Lordship. Now, Lordship, what happened, Lordship? The departmental proceeding was done, Lordship. And SOCOS was duly served. SOCOS notice was duly served on 9/01/2011, and thereafter, Lordship, the DP drawn, Lordship, and accordingly, after completion of the departmental proceeding on 29/9/2011.
He did not participate.
Lordship.
He did not participate.
Lordship. But serve the SOCOS was served, Lordship.
Yes, what is the delay?
What?
What about the delay?
My lord, I was, and that time I was in treatment.
Where? What
After,
treatment?
my lord,
What treatment?
my lord, after dismissal order,
Hmm.
I engaged an advocate, that is Abdul Malik, who is expert man in Honorable Gauhati High Court. That's such delay, my lord. The delay is ground in my writ petition, my lord.
Where?
My
Which paragraph?
My lord, my admitted submission is that.
Which paragraph, Mr. Das?
Huh?
Which paragraph? Delay.
That typically makes it that the executive order or dismissal order that petition based state that after is the that petition he was undergoing so it's a protection that petition is that even of the
Where is the?
It is mentioned by the.
Para 14.
I consider the. That is the input or additional order are doing really by taking into context. But High Court order was finished in this regarding petition of back to state that he did not have any case before the Honorable High Court. That petition back to state that page 18. That order dated by member authority, it is given that in paragraph about
Para 14, page 14.
Para 14. The petitioner begs to state that after having receipt of the said order, the petitioner engaged an advocate namely Abdul Malik, in the year 2012 for taking necessary steps with regard to this case until he expires. Therefore, petitioner made an RTI application through the newly case. My lord, in RTI application, my lord, kindly see the order, page 60. Order of the
Not satisfactory.
Huh?
Not satisfactory.
The order is not satisfactory, my lord.
No.
My lord, it is contrary. The order is contrary, my lord. In the order, it is predetermined order, my lord. I was not apprised. My disease, my medical certificate is page 48. Predeterminedly, I am dismissed from the service, my lord. Predeterminedly. I given my medical certificate, my lord.
You got the show cause notice, you received the show cause notice.
My notice, so cause notice.
You received,
So could have, first I was not so cause notice. Secondly, I so cause notice. Afterwards, I given so first so cause notice reply, second so cause reply, and then the second so it is reflected that I have no liberty to defend my case.
anything more?
Even any case, my lord, as per my lord, it is other provisions of the disciplinary proceeding validity. The Assam Police Manual, Part 3 of Rule 66 clearly lays down that the inquiry oral evidence shall be heard to such of the allegation as not be admitted and are not admitted, and the person such shall be entitled to cross-examine the witness.
Where is the inquiry report?
Inquiry, my lord, inquiry.
Page 57, Lords. Annexure 9.
Why did you not appear in the inquiry? Why did you not appear in the inquiry? Because you were fit by that time as per Annexure 1.
My lord, I was not given the chance.
Where have you said? Where have you said?
The witness, my lord.
Where have you said that in your writ petition?
It is, my lord. Page 30 petition stated that the input order was page 19, which without taking into consideration the documents, which clearly the authenticity of the petitioner's thesis and island is of absence. Before passing the order dated of so-and-so inquiry, the petitioner could not able to defend himself. Following the process of law, the proper opportunity was not given to the petitioner to present.
Okay, where have you written to the authorities that you are suffering from some ailment? That's why you are not in a position to join your services.
It's, my lord, it is compelling psychiatrist, my lord.
What?
They will complain my physiatry disease, my lord. It is written, my lord. It is so much written, my lord.
Where?
That the petition it is so much written. From the year 1995, page 12, page 12. Page 12 and page 16, 6, 7. The petitioner stated that while he got ready for joining the service to resume his duties, my lord, after taking my fitness certificate, medical certificate to join to my job, I was punished, my lord. I taking quarter guard, PW, punishment. How is it? It is predetermined, my lord. Page 6, 7. so much medical documents are attached.
Okay.
Documents are not
Anything more?
took, my lord.
Anything more?
Hmm?
Anything more?
I will give the judgment, my lord, some.
Heard the learned counsel for the parties at length. Hearing concluded, registered to list this matter again on Friday. Kita answer delivery important. On Friday. Friday we'll pass the orders.
Lordship,
Yeah.
Maybe.
Hmm.
I have prepared a short written arguments with some citation or sheet. Regarding in the supersluship,
even
Yes, Mr.
not in the superfos. The charge has been framed under section lordship under rule 712P. That the punishment has been enforced under rule 7 rule sub rule lordship 7, that is dismissal from service.
That cannot be.
But not
Yes, Mr.
Lordship,
not I have given the list of documents and list of witnesses are not furnished. And in the second super notice, they in a predetermined manner, they issue the super notice agreeing with the agreement of the inquiry report. That was only I was. I have given the some citation to that effect.
Yes.
Lordship, apparently that show cause notice has mentioned that when a penalty under rule 7(1) to 3 should not be imposed upon you. But Lordship, in this case, from the
No, that
totality,
is the projection made. Why should he think about something else?
but
1, 2, 3, you will can impose 1, 2,
definitely,
3.
Lordship, in the show cause notice as part of the rule, there is no requirement to give that this is.
But once you have given it, that is that you have yourself mentioned it.
Yes, that may be the mistake on the part of that officer,
That
but
you proceed against that person who issued that. Why are you proceeding against the petition?
But from the conduct of departmental proceeding, we have seen, Lordship, that everything is been conducted for imposition of the penalty as per Rule 9, Lordship. There
Rule
is
9?
Rule 9. By following Rule 9, that everything is conducted, Lordship.
But
So there is no
main
element.
effect is in the show cause. You
Lordship.
can't go beyond.
But there is no element, Lordship.
Once you have issued a minor penalty show cause, how can you impose a major penalty? Other way around is permissible.
Yes.
But this is not done.
There was no.
You are not required to do it. You support your
yes,
submission that even if this is there,
Lordship.
still punishment under Rule 7 as per the provisions of Rule 9, 11 or 12.
12.
That decision can be taken at that stage.
Lordship.
You support. Please.
In Lordship, data part, Lordship, for that I cannot presume that is
First,
the correct.
get out of this, then we will see the later part. Make your submissions.
In this,
And such a serious matter, last 4 years, you have not even cared to file a affidavit. Non-traverse, we'll allow it.
even
You suffer.
Lordship, from the pleading of petitioner side, Lordship, that page 48, which is the Lordship show cause notice, Lordship. The allegation against him is quite serious that he was.
Who said the allegation is not serious?
Lordship.
Who said the allegation is not serious? I'm not saying.
That provision of law, provision of rule, which ought not to be put in the show cause notice, was put by the officer.
Once you have put that, you are bound by that.
That is the decision I have made. Once it is mentioned,
Then that is the end of the matter.
There was more.
We can do one thing. You are still in service,
No, no.
retired,
Retired in 2019.
2019, and the proceeding was concluded on?
That is 2024.
And how can you punish him after his retirement with a penalty of dismissal from service? I think this is a fit case for imposing cost.
So for 2014 itself,
Sorry, 14.
14 Lordship,
14.
Before your retirement.
before
No,
retirement.
before my retirement, but after filing this writ petition, filing the first writ petition.
That
They were
is,
sitting over.
filing of writ petition, was there a stay?
No. That was in the first round of litigation. They were sitting over the matter for long, more than Lordship 7-8 years.
Except that Lordship in the show cause notice, Lordship, all the witnesses has been examined, the charge has been properly explained to him, and he has participated in the trial. And the order passed at page 84 is also in conformity with that rule, Lordship.
In fact,
12
the
Lordship.
suppose there is no list of witnesses, no list of documents. That has vitiated the proceeding.
The person, Lordship, who has applied away from India and opted for a private job in the foreign countries has, by submitting a application million.
And that I have given as many as 6,
What are these decisions for?
my lord. First case Lordship regarding imposition of penalty higher than the provision mentioned in the suppos. Here are 2 less. অমূল্য চন্দ্র দাস।
ये सीखे की है मतलब
And the second one, LCP College?
And second one, Lordship, on the same point, there are 35 only. In that case, this honorable court held that in the event the super's notice is mentioned the provision, but during the proceeding, they could have altered the charges. That was not done in this case.
Yes, Mr. Doctor, any decision?
Lordship, we have not found any decision, but the one decision I have found recent judgment again in favor of him only. That Lordship, Nigam Prakash Narayan case, Lordship, 2026.
2026?
2026, HCC Online, SC 813. Dr. Nigam Prakash Narayan versus National Medical Commission. You
8-1?
can 813.
What is the ratio?
Ratio that you cannot impose the higher penalty than it is prescribed.
That is the law.
It is a law, Lordship, but in this Vedanto,
Okay.
our standing council of Vedanto.
Give him
first
that copy. He'll take it.
I'm good.
Print out like
Lordship, matter may be fixed on Wednesday. On that day, Lordship,
Huh?
matter may be fixed on Wednesday. Sorry, next Friday.
Today.
Earlier, Lordship, Vedanto Kochi was appearing and he was submitting in a lot before Lordship.
You are appearing today. No issue. Good, yeah, second of October will be.
Sorry, my lord, I was not informed that it will be taken today, my lord, while serving the copy in the morning, my lord.
Okay, no issue. Yes, what is the issue here?
My lord, the issue is, my lord, the state health department, my lord, has made a policy for the quota of a special category of those persons, my lord, daughter serving in the, my lord, defense personnel, serving defense personnel, my lord. And my lord, I belong to that quota, my lord, and my certificate, my lord, I have also annexed that they have certified that I fall within that category, my lord. Is that, my lord, page 29, annex of 4 is my certificate. Now, my lord, after the declaration of the result, a series of notification had been issued by the Director of my lord, Medical Education in the nature of educational notices, my lord. I beg to draw my lordship's attention to page 31, annex of 5, my lord.
Yes, annexure.
Lord, page 31, annexure 5 is a notification dated 10th of August 2026, my lord. Issued on 15:45 and 42 second, my lord.
Now,
And my
give
lord,
me a background of yours.
my lord, my background is that, my lord, I belong to the category of this, my lord, defense personnel quotas provision, my lord. I being the daughter of a serving defense personnel. Just for a moment, my lord, if my lord peruse annexure 31, page 31, annexure 5, it will clarify, my lord. May I read, my lord, the first paragraph says, this is for general information of all candidates who have applied by this directorate notice number dated 5/8/26 for admission into the first year MBBS BDS courses in the government medical and dental colleges of Assam session 2026 under special quota. These are the, my lord, categories: freedom fighter, matrix of Assam.
Did you appear?
Yes, my lord, I have applied under the serving defense personnel / sports quota. Now, my lord, this is the timeline they have fixed, that the date of document verification is the 12th of August 2026. My lord, I fall within the first category, that is ex-servicemen, and serving defense personnel starts from 10 a.m. onwards, my lord. Now, the difficulty is that, my lord, I am, my lord, residing in a very remote area, my lord. In my place, my lord, the internet connectivity as well as the, my lord, electricity connection is also.
Where are you?
Yes, my lord, I have stated in my specific paragraph, my lord. My lord, may kindly turn to page 10, paragraph 10, my lord.
Then it.
My lord, my lord. In fact, my lord, this is the main reason, my lord. Now, my lord, as I have missed the date.
Now, you mean to say that from Kokrajhar district, no student had applied?
No, my lord, I am in a remote area in Duramari, my lord. For the defense personnel quota, my lord, whether in that category some person has applied or not, my lord, that instruction I do not have, my lord. But it is the my fact situation, my lord. I have just stated on oath before my lord.
But this process is over by now.
No, my lord, this process, my lord, as per the notification, my lord, at page 31, it is on only one date, my lord. That is 12th of August 2026. That from 10 a.m. onwards. There is no other date, my lord. So, my lord, it has said that 12th August 2026, as per schedule mentioned above, failing which the claim for the particular special quota will be forfeited. They are also directed to bring a set of photocopies of all relevant documents and annexed for submission. My lord, it was the date for, my lord, physical verification of the document which I relied and which my lord, make me eligible for the purpose of, my lord, admission into the MBBS and BDS courses. So under the quota, my lord, as I could not apply, so, my lord, what has happened? I now belong to a general category, my lord, candidate, and in that general category provisional list, my lord, may be pleased to find is at page 33, my lord. Educational notice, and in that, my lord, provisional Assam state merit list of the NEET UG 2026, my lord, my name appeared under serial number, my lord, at page 35, serial number 3814, my lord. Of 414, my lord, my marks and other category had also been shown. Now, my lord, in the quota category, my lord, in this mark, my lord, I may not be allowed to, my lord, not get the opportunity of admission, or I may miss out the benefit of the quota, my lord. So, therefore, my lord, I know, my lord, that I have done a mistake, my lord. It is admitted as per the notice, my lord. So therefore, my lord, I am now before at the mercy of my lordships, my lord, that a direction, my lord, as in the similar category of a person, my lord, a recent direction has been issued, my lord. I have also annexed that petitioner's order, my lord, it is at page 37. My lord, the relevant part starts from page 37, my lord. Only a representation has been, my lord, allowed to be directed to claim the benefit. And my lord, if a similar order, my lordship, if I can satisfy my lordships, my lord, the fact situation, my lord, I will make a representation and they will consider, my lord. That much, my lord, relief I am asking for, my lord.
But again,
My
today we are on 18.
That
The
is correct,
things
my
have
lord, that
moved
is correct,
beyond-
but
Beyond repair now.
no, my lord, what has happened, this, if we go by the schedule, my lord, it is, huh? Page number, if my lord may kindly turn to page 36, my lord. This is the schedule, my lord, fixed, after this, what will happen, my lord, after, 12/8, my lord. Online registration and the first round of counseling, my lord, will start from 13/8. Then, my lord, online filling, of the choices. my
So
lord,
today is the
16/8,
time.
18, my lord.
Today is the day.
Today is the date, my lord. My lord, I can, huh? My lord, I have already registered, my lord. I have already registered on
Your
in the
registration is on general.
general category, my lord. Only thing is that, my lord,
Yes, Mr. Boravati.
My lord, I have, just now I have obtained a specific instruction regarding the defense personnel quota, my lord. There is a Sonic board, my lord. On the day of the verification of the documents, that members of that board was also there, and they have scrutinized the documents of the students belonging to this particular category, and thereafter a list has been prepared, my lord. And from that list, my lord, all the candidates have already made their choice filling also, my lord. So my lord, now at this stage, my lord, otherwise also the petitioner cannot be accommodated. If, my lord, after first round of admission, if any seat fell vacant, my lord,
Then she will be. Considered.
then maybe, my lord, I don't know whether the authorities.
That is not a, that is in the realm of.
Yes, my lord.
possibility.
Yes, my lord. But otherwise, my lord, at this point, my lord, for this present online counseling, my lord, her candidature cannot be considered, my lord.
Okay, you will follow the decision of the coordinate bench.
my lord, my
You
lord.
pass an order on
Yes,
that
my
line.
lord.
My lord.
Later,
But Mr. A.R. Leonard Senior Counsel, assisted by Mr.
Yes, Abdullah.
S. Abdullah, Leonard Counsel for the petitioner. Also heard Mr. D.P. Bora, Leonard Standing Counsel, Health Department. The petitioner hearing had cleared the NIT 2026, NIT dash UG dash 2026. Where did you appear from?
My lord, I appear from, my lord, my lord, my NET result is at page 27, my lord. Annexure 2, my lord. My lord, I appeared from Rajasthan, my lord, state of Rajasthan.
Kota.
My lord. My lord, some people goes there for better result, my lord. Now this is the result, my lord.
From Kota, Rajasthan. So the petitioner further projects that her father is a serving army personnel in the rank of Subedar. And accordingly, the petitioner is entitled to have her case considered for the quota reserved for ex-servicemen, Roman and serving defense personnel in the MBBS course. So, the respondent authorities had issued a notification, educational notice dated 10/8/2026, requiring the candidates claiming a reservation against the quota mentioned therein to appear on the date so mentioned, a date and time so mentioned, for verification of their documents offline. It was further stipulated therein that in the event the candidate does not so physically appear before the respective boards for document verification on the date and time so specified for each of the quota, comma, their claim for a particular special quota would stand forfeited. The petitioner has further projected that on account of the fact that she resides in a remote and rural part of the state where the availability of internet facilities, access to online information are limited, and further on account of there being no electricity in the area on account of, that is what your case is. Where have you said that?
My lord, at paragraph 10 at page 10, my lord.
Area with effect from 10/8/2026 to 13/8/2026 on account of heavy rains, comma, the petitioner was not in a position to access the internet and or other means of dissemination of information. So accordingly, it is projected that the petitioner had missed the deadline as fixed by the educational notice dated 10/8/2026 for appearing before the constituted board for document verification on 12/8/2026 at 10 a.m. for staking her claim for being considered against the ex-serviceman and serving defense personnel quota. Also, it is further projected by the petitioner that the name of the petitioner has, however, been included in the provisional Assam State merit list for NEET UG-2026, and she is placed at serial number 3814 therein. However, it is submitted that on account of the for the reasons as noticed herein above, which were beyond her control, comma, the petitioner had missed a chance to have her case considered for pursuing the MBBS course against the quota reserved for ex-servicemen and serving defense personnel in terms of the educational notice dated 10/8/2026. Mr. D.P. Bora, Mr. A.R. Bria, Learned Counsel for the respondent, has reiterated the said projections made in the writ petition and has submitted that under similar circumstances, a coordinate bench of this court wide order dated 14/8/2026 passed in WPC number 4399/2026 Akhirul Islam versus State of Assam and others, permitted the petitioner therein to file a detailed representation explaining his condition before the Director of Medical Education, and the Director of Medical Education was directed to consider the said representation sympathetically and pass appropriate orders thereon. Also, he submits that the petitioner hearing being similarly situated, comma, a similar direction be passed in respect of the petitioner herein also. Mr. D.P. Bora, Learned Counsel for the Learned Standing Counsel appearing for the Health Department, submits that the educational notice issued on 10/8/2026 was complied with by the other claimants for the quotas mentioned therein without any objection, and the plea now taken by the petitioner in the matter would not mandate an acceptance from this court. He submits that the verification of documents with respect to candidates claiming reservation against the claiming preference against the ex-serviceman of and serving defense personnel was so conducted by also including in the committee in the board members of the Sainik board. He submits that it would not be permissible for the respondent authorities to again carry out such verification.
And that is completed and list has also been published.
Verification by also including the Sainik board members when the exercise was already undertaken and a list of candidates found suitable for being considered against the ex-servicemen and serving defense personnel quota was prepared and published. Also, I have heard the learned counsel for the parties and peruse the materials available on record. Considering the submissions of the learned counsel for the parties and also on perusal of the materials coming on record, this court is of the considered view that the process with regard to admissions to MBBS course being carried out in a structured manner, any mandamus issued by this court at this juncture may have the effect of disrupting such procedure which is being so followed by the respondent authorities. However, considering the grievance raised by the petitioner, this court is of the view that in the event of this court is of the view that it would be appropriate to permit the petitioner to file a detailed representation explaining her condition before the Director, Medical Education Board, (DME), Assam, with a further prayer to permit to facilitate verification of her documents for consideration of her case against the quota reserved for ex-servicemen and serving defense personnel.
In the second round of counseling.
That I'm not saying, that you do. So, such representation is undertaken to be filed during the course of the day. So, in the event of filing of such representation during the course of the day, the DME, Assam, shall consider the same and dispose of the grievance, shall consider and dispose of the same by addressing the grievance of the petitioner raised therein and communicate the order to the petitioner. I was here for para 6 and para 7. It am idea.
Cannot be sympathetically.
I would consider the same sympathetically.
Fine.
The direction passed by this court, para 7, herein to consider the representation of the petitioner shall be so considered so as to not cause prejudice to any other similarly situated candidate. Petition with the above without expressing anything, the petition stands disposed of. Para 7. Try your luck.
My lord,
Again,
deeply obliged.
I'll try to give the copy now only.
Yes, yes.
The copy can be given, certificate can be given by one. The court master to give, he will have a signed copy. He will have
True copy.
true copy. To furnish a true copy of the order to the learned counsel for the petitioner during the course of the day.
Deeply obliged, deeply obliged.
We have said during the course of the day, you can do it.
My lord, by 5 p.m. office will be closed, my lord.
By 11 p.m. tomorrow.
Tomorrow, yes.
By 11 p.m. tomorrow.
Obliged.
11 a.m.
My lord.
Lordship,
Obliged, my lord.
Lordship, my senior is on legs in court 10. Kindly pass over the matter for some time.
You're ready?
Lordship, there are some legs. It's raised as.
It is submitted that the learned counsel for the parties are busy with some other matters and accordingly have not appeared before this court. So in view of the above, the registry to list these matters again after 4 weeks on a date to be fixed by it. The matter be not treated to be parted and or tied up matter with this court any further. Item number 20, 21, 22. Yes. Miss K. Pukan, learned standing counsel. AGCL is present.
I'm in 22, my lord.
You are ready? 22 people. Yes.
Sorry, I can do 27 now, I think.
Get out on me. 20, 21. It will time being good person. Yes, counsel. Called up. We'll take it up after some time. We'll take it up after some. Tell him also. We'll take it up after some time. Imam? Yes. Yes, what is this? This seems to be a non-ending thing.
Lordship.
After the last order, what happened?
After the last order, Your Lordship, review selection was held. And review selection, Your Lordship, I was selected by the selection committee, then matter come to the state level.
You are Gangadhar Burman.
Gangadhar Burman. Now, Your Lordship, he raised a complaint, and based on that complaint, Your Lordship, they have reduced my mark by 4, and I came down to 13, Your Lordship. And I have challenged that, Your Lordship. In the meanwhile, he retired from service. Out of the 3 candidates, I am the only one who is still in service, Your Lordship.
Show me how the marks were reduced.
Lordship.
The crux of the matter is there only.
Lordship, that is, Your Lordship. Your Lordship may kindly come to page 49. This is the speaking order.
So, school selection committee recommended you.
Recommended.
Then state selection committee?
Based on a complaint lodged by my friend's client, Your Lordship, they passed the speaking order, which is at page 49.
Okay.
May I read, Your Lordship? Read and peruse the speaking order number so-and-so that is issued by the Director Secondary Education Assam in compliance with the Honorable High Court, Honorable Gauhati High Court's order dated so-and-so in WPC 2776 of 2020 linked case WPC number so-and-so filed by Gangadhar Burman, whereby respondent number 6 Jayanto Kumar Burman, Principal Belsor HS School, was reverted back to the post of graduate teacher of Belsor HS School, Nalbari, and SSB branch of the Directorate of Secondary Assam was directed to initiate necessary process to carry out a review selection among the candidates so participating in the pursuance of the advertisement issued in the month of December 2018 for the post of Principal Belsor Higher Secondary School. Also read and peruse the hearing report of the state selection will hold on 30/10/2025 in connection with the Honorable High Court's order dated 6/9/2024 passed in WBC number 2776 of 2020, link case number
Earlier for administrative experience, how many marks you were given?
4 euros.
Leadership skill,
Everything else remains same, Your Lordship.
only administrative ability?
Yes, Your Lordship.
Huh? Or the leadership skill?
No, only leadership skill, Your Lordship.
Leadership skill.
There, Your Lordship. These are the two grounds on which they have refused to give me any marks. First, Your Lordship, that in the third paragraph, as per hearing report so and so.
Okay. Where is that criteria that it was here somewhere?
That the office memorandum, Your Lordship will get it
Page
at page
47.
47.
So leadership quality skills.
On the basis
Results
of
of
this,
HSLC AHM examination in case of graduate teacher
Lordship.
and HS final examination so and so. School where he is a teacher, results of so and so should be excluded. So
90% and above 4 marks.
4 marks. So your school had 50% and above.
No, not 50.
Sorry, 90% and above.
That is, Your Lordship, as per earlier report, Your Lordship. Now they have relied on a Your Lordship certificate issued by the present principal, which says that it was not 90% and above, Your Lordship. They say, Your Lordship. Now, which is in fact not correct, Your Lordship. Why it is not correct, Your Lordship will kindly come to page 55.
So this would be for the which period?
For the Your Lordship 2016 to 2018, Your Lordship, period for which?
Preceding year of this election.
Lordship.
So the selection was in the year?
2018.
First selection.
Lordship.
So 2000, it will be of 2017.
Lordship.
So 2017, there are two grounds that the
One is
percentage that you give is inflated.
Not me, Your Lordship. It is by the deed and Lordship.
Whoever it is,
Lordship.
in your favor,
Lordship.
it was inflated.
Lordship.
So that has to come down
Lordship.
to 60%. Then
Not
you will be
80
getting
or something.
you will
80.
be getting 2 marks.
2 marks.
So even if I give you, if you get 2 marks, you don't come
No.
to the first position. Second question is that when you had 2017, that period, you were not in the school.
Lordship,
You
that
were
is
a
BRCC. BRCC.
BRCC,
Block Resource
defense.
Lordship.
Now, when you are a BRCC, you
Lord-
don't teach in the school.
No, Your Lordship, what we need to do, Your Lordship, the first class we have to take, Your Lordship. Number 1, Your Lordship.
Where do I get it?
Lordship, that is circular. I have, Your Lordship, annexed that circular.
But here it is said that is not reflected in the attendance register of
So
this.
that, Your Lordship, I don't know, Your Lordship. That's how everything got changed now, Your Lordship. And in fact, Your Lordship, selection committee has filed a affidavit, Your Lordship. Their affidavit makes it everything clear, Your Lordship. Your Lordship will kindly come to page 51. And Your Lordship will kindly see my substantive post remain in the school.
That is true.
Lordship, I draw salary from the school and I do more than what a teacher is required to be done, Your Lordship. In a block, Your Lordship, I engage in capacity building, Your Lordship, of teachers, Your Lordship. Now for that, shall I be penalized, Your Lordship? And this is relatable to, Your Lordship, Article 21A.
What is the stand of the selection committee?
Selection committee, Your Lordship, they have filed their affidavit. Your Lordship will kindly come to their affidavit, Your Lordship.
Respondent number?
5.
Mr. Goswami is appearing.
Your Lordship.
Respondent number 5.
5.
Affidavit by Rajeshwar Muzumdar.
Lordship. Para 2, Your Lordship.
Okay, let us see what is there.
Para 2 and para 4, Your Lordship.
Para 4 also.
Lordship.
Where are the certificates referred to therein? Some certificate by the principal,
Lordship, the then principal, your lordship, not now, your lordship, at
Uh-huh.
the time of selection, your lordship. This is-
certified that so-and-so, he always came to the school in every working day and takes first period of class. So-and-so, so-and-so, so-and-so. When was the second review selection held?
Lordship, the second review was held, your lordship, here itself it was stated. 6/9/2000, no,
6/9?
no, 25/6/2025.
20?
Page 61 euros, 61. When review of the selection has been held, that is on 25/6/2025. Now, so far as that 90% or above is concerned, your lordship will kindly take up my petition for a moment and page 55 euros.
Petition.
Writ petition.
Hmm.
Your lordship will find serial number 5, your lordship, Dilip Rajbonghi. He belongs to same school as of mine.
Hmm.
He was given in the leadership school 4 marks, your lordship. If at all it is not 90% and above, how he kept this, it is 2018 itself, your lordship.
And where are the minutes of the current selection?
That, your lordship, minutes has not been annexed.
So serial
Order
number
is-
4 is from your school.
Lords. 5 euros.
Yes, Mr. Soikia, what is your case?
My lord,
And
first of all,
one more thing, your lordship. In the meanwhile, while he was in charge, your lordship, proceeding has been drawn against him, your lordship, before retirement. And your lordship, so cause has also been issued under Rule 9 of the Assam Service Discipline Appeal Rules. That is pending.
Yes.
First of all, my lord, that is the question of disputed question.
Huh?
He has raised the disputed question of law, my lord.
What disputed?
Because my lord, the authority says the school has lesser percentage of my lord, students pass in the matriculation examination. He is saying
Are you
that-
from the same school?
Yes, no, man. I'm from the.
No,
same
were
school.
you in the school wherein the post of principal is being filled up?
Yes, man.
Huh? So you were the in charge principal.
Yes, man.
So 2019, first selection was of
He's
2000.
from a different school.
Original, he is from a different school. Oh, he is from a different.
Different.
Different school.
Then why was the other person given
My
4
lord,
marks?
I'm pointing out a page 55, my lord, which my friend has relied on, my lord.
Hmm.
That is in respect of a different school, my lord. In respect of a different school, my lord. What was his score in that school? He scored 13 marks. He is at serial number 8, my lord. He scored 13 marks. That selection was never challenged by him.
Olmara. Yes.
That selection was never
No,
challenged
your
by him.
lordship will kindly. see-
Therein also you were given 0.
No, that is given 0 on the ground that your lordship will kindly see the remarks column. That is the reason, your lordship. Why? And that's why, your lordship, that certificate, your lordship. This is your lordship. This is the reason that
What is-
I was not in. Column, your lordship, remarks column, your lordship.
Now, how does it change? This is interview of 2011.
No,
How can
not 11.
2015 to 2018 be considered?
No, this is 18/11. 2018.
Over you
10,
see,
1, 2018.
18.
10/1/2011 date of interview.
No, your lordship. 18/12/2028. 2018.
Oh, that you typed out the wrong way.
Your lordship.
Ah,
Sorry, your
it
lordship.
is 19.
Page 55, your lordship.
Yes,
may carry.
55, my lord. Date of interview is 10/1/2018.
10/1
His leadership mark has not been counted due to not working as teacher
Lordship.
in the school from 2015 to 2018.
That is the
Lordship.
case.
So you are CRCC.
Lordship.
Yes.
No, BRCC. your lordship.
BRCC.
BRCC, my lord, in respect of BRCC, my lord, my friend has relied on page 51. In respect of this is, my lord, in respect of CRCC, not in respect of BRCC, my lord.
Lordship.
Yes.
This,
Where is that? Where is that?
Page 51. Attending the first class, that is in respect of CRCC, not in respect of BRCC.
same
In respect of
principle.
the school, my
Same,
Show me.
same.
That much only you should.
No, your lordship will kindly see. Same principle is followed in respect of BRCC. Your lordship will kindly see the memo number at page 52. SSA, ESTT, CRC, BRC engagement, your lordship.
But here, it only says about CRCC.
But your lordship, the same, and that has been certified by the earlier principal, your lordship. School authority, your lordship. And your lordship will kindly see, that is the principle, your lordship. And that has been, your lordship, housed by the selection committee, your lordship.
Now you are out.
No, now he is out, your lordship. Even otherwise also he will not get.
Lordship, kindly see my affidavit in opposition. I have filed paragraph 4 onwards, my lord.
No, you are out means you have retired.
I have retired.
How can you be appointed as principal?
I retired, my lord, after the selection was made.
That will not give you anything.
I will get the benefit, my lord.
You will not. There has to be an order. You were holding the charge. It's a direct recruitment post.
No.
It's not a promotional post. It's a direct recruitment post.
Earlier I was appointed by the authority, my lord, a regular principal.
That we had interfered.
That was interfered with. Against that, my lord, I prepared a review. During pendency of the review, my lord,
You retired.
the fresh selection was made. No, I did not retire, my lord. The fresh selection was made. And after that selection was made, lordship was of the view that, my lord, I should approach the authority for a appointment. And in the meantime, my lord, I retired. So, my lord, I am entitled to the benefit of the
But
post.
last time when these matters were being taken up, it was administrative ability which was the issue in contention.
They have
Leadership was
never in question, your
Yes,
lordship.
that point was never raised.
Then how can you raise it now?
No, that is why, my lord, the review petition was filed. That is why the review petition was
The
filed.
review, we have not recalled the order.
No, lordship, my lord, granted liberty. Review petition.
How old are you now, Mr. Botago?
Lordship. As per affidavit.
55, 25, 56. Yes, who is for the government?
The review order was filed WPC 6724, page 59.
Why have you filed this writ petition?
My lord, for praying for appointment as principal, my lord, after the fresh selection was made.
Any affidavit by the government? No.
No, my lord.
Yes.
Lordship, referring to page 49, Lordship. The impugn order, challenge hearing, Lordship. And Lordship. vis-a-vis
Okay,
Lordship-
justify the last paragraph.
Yes, Lordship. Page 88 also, Lordship. Page 88 of the affidavit in opposition filed by Lordship, that respond number 6 in this matter. That wherein that guideline has been formulated by the office memorandum has been formulated, giving the guideline of Lordship marking. And my humble submission in this case, Lordship, it is a subjective satisfaction on the part of the respondent authority selection committee, Lordship. So it is
Your leadership quality, academic career, administrative ability, leadership skills, this cannot be subjective.
yes,
These have to be objective because it's based on some data.
Lordship.
It cannot vary.
That's why page 88, Lordship, I am referring.
88, that is the office memorandum, 26.
Yes.
This administrative leadership skill,
Skill.
can
Result of
the selection committee member
Lordship.
give marks beyond the last column?
No,
Can't.
no,
Administrative ability, can it give?
no, Lordship.
These are all fixed parameters.
Yes, yes.
You have it, you
Award
get
of
it.
2 mark for a state and national.
Academic career,
Lordship.
can you give a mark other than this?
No, no. That's why, Lordship, I am referring to that page 88, Lordship.
88.
And on the basis of, Lordship, page 88, that mark in page 49 has been given, Lordship, is my humble submission by the selection committee.
No, you say
Lordship.
two things. Selection committee had given him the marks,
Yes,
school selection committee. State selection committee did something.
Did something.
What is the justification for that?
That Lordship, I'll have.
You have written this third paragraph.
Yes.
Where is the justification? You have said that he is a CRCC or
Yes.
BRCC, whatever it is. For that period, he will not get. Where is the justification?
That I will have to produce record, Lordship.
Why? Why? When is the matter filed? 25.
25.
How many dates?
Because the thing, it is.
First day you were not there. Second day, A9126 notices issued.
Lordship, better if we keep on next week, Lordship, I'll produce the entire record, Lordship.
No,
Because
we want the justification from your director of her this conclusions in para 49.
here, Lordship, that director's justification is on the basis of, Lordship, he is being a member secretary of the selection committee. So that.
Because this was never the plea taken in the earlier round of litigation.
That's it. So, Lordship, I may be allowed to produce the record that if that.
Who prevented you?
Because there is no order from this court, Lordship, that's why. Anyway, Lordship.
No order? Okay.
Lordship, kindly give me 7 days time, we'll produce the record, Lordship. If record is something that petitioner will get. Otherwise, Lordship, in my humble submission, it will have to assess in terms of page 88, nothing beyond that.
Fine, we go to page 88.
Yes.
Page 88 has been applied twice now. Earlier ones, it was only integrity and administrative. We have cleared that.
Yes.
Now you come back and say, no, leadership also. How can you? It is what do you call that? Constructive res judicata. You can't take a plea which you have taken earlier.
That point was raised by me, madam, after obtaining the information under RTI. That point was raised by me during the review petition as well as in the application.
No, why that point was not raised, which is not raised? This is just a review. You will have to go by the data that is there already.
Yes.
You can't have new data.
That information was not there earlier, my lord. I did
Mr.
not get that
Soikia,
information.
this is not a fresh selection.
Yes,
This is a selection continuation of the earlier one.
yes.
You are not required to bring on record any further material. That is the question of review. Basing on what is there,
Yes.
do a review.
But
Finished.
final informations regarding his working as BRCC,
That cannot be.
that was not placed before the court in earlier under litigation.
If the authorities have not taken it, authorities know that he is a PRCC.
But my lord, in the guideline, if a lawsuit comes to the guideline at page 47, it says result of HSLC AHM examination in case of graduate teacher and HS final examination in case of postgraduate teacher in the school where he is a teacher.
And he is not out of the school because of some personal area. He
That
has
is
been
his
given
choice, my
a,
lord. That is his choice. It was not his deputation, my lord.
no. It
He
was,
went on his own,
he is doing a job
doing
for
fully
the,
well.
he is doing a job for the department only.
Oh, that is true. But he knowing
That does
fully
not
well,
cut ice.
knowing fully well about the my lord, consequences, he joined the
But
as
the
CRC, my
learned
lord.
counsel for the parties at some length. Mr. P.P. Dr. Learned, Standing Counsel, Secondary Education Department, shall on the next date of listing receive in writing instructions from the Director of Secondary Education Assam with regard to the basis for the grounds cited in the order dated 2/11/2025 issued towards finalizing the selection process for the post of principal in Belsor High Secondary School, Nolbari. The director shall also apprise this court as to the basis on which the petitioner on his deputation as block resource person was held to be not entitled to any marks for apostrophe bitorat leadership skills. Also, the director shall also explain as to how fresh materials were considered when the Direction of this court in the earlier round of litigation was only to carry out a review selection in the matter. Raised it to list this matter again on 25/8/2026, reflecting the name of Mr. P.P. Dr. Learned Standing Counsel, Elementary Education Department in the first list. We don't want the records. We don't want the records. We want the justification. You pray, you get it. Who asked you? You are a standing counsel, you can get the records. I don't want the records. I want a justification. A justification, along with corresponding documents. Get it? We'll dismiss Mr. Bhatta's petition.
Yeah, please, Your Honor. Let the impugn order of penalty of withholding money increment has been passed. Page 33.
Who was there yesterday opposing you? Joagali Kuna
It was,
Tarangpi. Nam Dekone. Yes, madam. Anything to add? Heard Mr. B. M. Deka, Learned Counsel for the petitioner. Also heard Ms. H. Tarangpi, Learned Standing Counsel, Secondary Education Department. The petitioner in the present petition has presented a challenge to an order dated 20/03/2013, imposing upon him the penalty issued by the Inspector of Schools, Nalbari District Circle, Nalbari, imposing upon him the penalty of withholding of 1 increment with cumulative effect, and also regularizing the period of suspension as on duty for pensionary benefit only, and directing that the petitioner shall not be entitled to any salaries for the period of his suspension. So, the petitioner herein was appointed as a laboratory bearer in the year at Chamota Higher Secondary School in the year 1995. So thereafter, he was promoted to the post of lower division assistant, presently junior assistant, bracket over, in the year 2000. So, the petitioner, while serving as a junior assistant at the said school, he was authorized by the principal of the school, via a communication dated 20/2/2012, to collect the HSLC question papers of the examination of question papers from Belso Police Station. They said examination was scheduled to be held with effect from 24/2/2001 to 21/3/2012. So, it is projected that in terms of the authorization as made in his favor by the principal of the school, principal or headmaster?
Lord Headmaster.
Headmaster of the school, the petitioner used to collect the question papers of the examination.
Lord Principal, it's a higher secondary.
Of the examination being held on a particular date. So, on 3/3/2012, as scheduled, the examination was to be held for the social science subject. And accordingly, the petitioner had gone to Belsor police station to collect the question paper of the said subject for the day as directed by the principal of the school. The petitioner collected the said question paper bundle, sealed bundle of the question paper. And the petitioner had brought the same and handed over. The petitioner thereafter came to the school and handed over the bundle, sealed bundle, to the officer in charge of the examination, officer in charge bracket confidential. The said question paper is projected to have been kept in the office almirah. Thereafter, when the bundle was opened and the question papers were being distributed, it was found that in lieu of the question papers for the social science subject, the police had handed over to the petitioner the question papers for the general science subject, which was so scheduled on a subsequent date. Also, in view of the said anomaly taking place in the matter, the petitioner was placed under suspension while an order dated 3/3/2012. Also, it is further projected that the petitioner was issued with a show cause notice on 1/10/2012, and the petitioner had submitted his reply thereto. Also, thereafter, the Inspector of Schools, Nolbari District Circle, Nolbari, while the order dated 23/2013, proceeded to impose upon the petitioner the penalty as noticed herein above. Also, the petitioner had thereafter instituted an appeal before the Director of Secondary Education, Kailipara. However, this said appeal remained. Said appeal still remains under consideration. Also, the petitioner has further projected that subsequently, it having come to the notice of the authorities that the petitioner was not in fault for the collection of the wrong bundle of the question paper, communications were made in this connection by the principal of the school to the Inspector of Schools. Also, however, no further action being taken in the matter, and the penalty as imposed upon the petitioner being continued with, the petitioner had instituted the present petition. Right? That's a fact.
Yes.
Mr. B.M. Decca, Learned Counsel for the petitioner, at the outset has submitted that the petitioner being handed over a sealed bundle of the question papers, it was not permissible for him to discern as to the subject for which the question papers were included in the said bundle. He submits that it is only after the opening of the bundle by the competent authority during the process of the examination that it was detected. It was detected that the question papers were not of social science subject, which was scheduled on the said date, but were of the science subject, which was scheduled on a subsequent date. He submits that also Mr. Uh, Mr. Decca, in support of his such submission, has referred to a communication dated 22/9/2017 issued by the principal Chamata High Secondary School to the Inspector of Schools NDC Nalbari, wherein the circumstances under which the mistake had so occasioned was set out, and it was projected that the petitioner was not, petitioner alone could not have been blamed for the said anomaly occasion. Also, it is further projected by Mr. By Mr. Decca that the jurisdictional inspector of schools had also, via a communication dated 1/12/2017, approached the Director of Secondary Education Assam for revoking the penalty imposed upon the petitioner and for regularization of his period of suspension. Had also approached the director so-and-so, requiring, seeking instruction as to whether the period of suspension of the petitioner can be regularized or not. Having made these said submissions, Mr. Decca has referring to the purported show cause notice issued to the petitioner, has submitted that the said show cause notice, the said communication dated 1/10/2012, which has now been projected as the show cause notice issued to the petitioner, in no way satisfies the requirement of a notice issued under the provisions of Rule 9(2) of the Rule Assam Services Discipline and Appeal Rules 1964. Mr. Decca has further submitted that a perusal of the impugned order dated 23/2013 would go to reveal that the penalty imposed upon the petitioner of withholding of one increment with cumulative effect was so imposed by invoking the provisions of Rule 7 of the Assam Services Discipline and Appeal over Rules 1964. He submits that a penalty under Rule 7 would be mandated to be so imposed only in the event a proceeding, a proper departmental proceeding is so instituted against the petitioner, is so instituted and conducted against the petitioner by following the provisions of Rule 9 of the said rules of 1964. He submits that in absence of a proceeding being instituted against the petitioner under the provisions of Rule 9(2) of the rules of 1964, it was not permissible for the respondent authorities to invoke the provisions of Rule 7 for the purpose of imposing any penalty upon the petitioner herein. In the above premises, Mr. Decca submits that the impugned order dated 23/2/2013 would mandate an interference from this court. Ms. S. Tarangpi. Sorry, H. Tarangpi. Yes, what is your submission?
Lordship, actually, we haven't.
Submits that in absence of any instructions being furnished to her by the departmental authorities, she is not in a position to make any submission in the matter. Anything more?
No, Your Lordship.
Also, I've heard the learned counsel for the parties and peruse the materials available on record. The facts noticed herein above are not in dispute. Also, the petitioner in the present writ petition has presented a challenge to an order dated 20/3/2013. Also, a perusal of the order, the said order being relevant, the same is extracted herein below. Have you given a type copy?
You know,
Page 32.
Lord, it's
30.
clear, I think.
A perusal of the same of the said order dated 23/2013 would go to reveal that basing on the show cause reply submitted by the purported show cause reply submitted by the petitioner on 3/10/2012 to the purported show cause notice dated 3/1/10/2012, comma, the jurisdictional inspector of schools had drawn a conclusion that the petitioner was guilty in the matter. Accordingly, by invoking the provisions of Rule 7 of the Assam Services, bracket Discipline and Appeal, bracket over Rules 1964, the date is also wrong. A penalty of withholding of one increment with cumulative effect was imposed upon the petitioner. Further, the manner in which his period of suspension is to be now regulated was also laid down. So, Rule 7 of the Rules of 1964 lays down the penalties permissible to be so imposed upon a government servant. So, Rule 9 of the Rules of 1964, however, mandate that no order imposing Rule 9, more particularly Rule 9 bracketed 1 of the said rules, mandate that no order imposing on a government servant any of the specific penalties specified in Rule 7 shall be passed except after an inquiry, comma, held as far as may be in the manner hereinafter provided. It is a settled position of law that a departmental proceeding under the provisions of the Rules of 1964 would stand instituted against a delinquent only on a notice, show cause notice being issued to the said delinquent, invoking under the provisions of Rule 9 bracketed 2. So, in the case on hand, a perusal of the communication dated 1/10/2012 would go to reveal that the same was in the form of an explanation call made, explanation call from the petitioner as to why a disciplinary action, departmental action shall not be instituted against him. The said communication dated 1/10/2012 in the considered view of this court cannot be elevated to the status of a show cause notice issued, invoking the provisions of Rule 9 bracketed 2 of the provision of the Rules of 1964. So, further, even if it is to be held that the communication dated 1/10/2012 had the effect of instituting a departmental proceeding against the petitioner, comma, the petitioner in his reply made there against him, having not admitted to the allegations leveled against him, comma, without first carrying out an inquiry in the matter as provided under the provisions of Rule 9, comma, it was not permissible for the jurisdictional inspector of schools to pass the order dated 23/2013, and that too imposing a penalty of withholding of one increment with cumulative effect, which in the considered view of this court is in the form of a major penalty. So, accordingly, this court having found that the order dated 23/2013 was issued invoking the provisions of Rule 7 of the Rules of 1964, but however, without following the provisions of Rule 9 of the said Rules of 1964, comma, in the considered view of this court, the said order dated 23/2013 would not be sustainable. So accordingly, the order dated 23/2013 stands set aside. The order dated 23/2013 having been set aside by this court, the respondent authorities are directed to reauthorize to the petitioner the increment withheld from him and thereafter to compute the pay and allowances of the petitioner by reckoning the said increment and to release to the petitioner his areas of pay so working out. The areas of pay working out to the petitioner shall be released to him within a period of 3 months from the date of receipt of a certified copy of this order. With the above observations and directions, the present petition stands disposed.
Much obliged. Much obliged.
Your Yes, Mr.
Your lordship may kindly,
What is this happening? Respondents council don't want to appear, then fine, we'll ask the government and common people to be here. I don't find anybody from the morning. Yes, Mr. Gauhati, you make your submissions.
your lordship will kindly see the last order.
Yes,
dated
yes, that is it.
Ah.
We had specifically directed. But Mr. B.D. Learned Counsel for the petition, Learned Senior Counsel for the petitioner, assisted by Mr. H. Agarwal, Learned Counsel for the petitioner. None appears for the Forest Department.
I here, just,
Sorry. Yes.
I've received the instructions also.
What is it? Now, if the government advocates are finding it inconvenient to come to this court, just let me know. I know how to handle my court. I'll have the officers standing here tomorrow. Today morning onwards, I'm facing this problem. Yes, what is it?
My lord had asked what was the basis of the promotion, my lord, that was revoked. I have the DPC minutes that says the basis of promotion was in 2001 itself.
21.
2021.
If that is so, my lord, my promotion remains intact and they can't recover the money and can't.
You do one thing, you give a copy of this to Mr.
Well,
So this is the basis now.
That's why, guys, your lordship can close it.
Mr. I. Bothako, Learned Standing Counsel, Forest Department, in terms of the directions passed by this court on 27/2026, has placed on record the minutes of the selection committee for selection of officers for promotion from forest rangers to assistant conservator of forest held on 16/2/2021. Mr. Bothako to furnish a copy thereof to the learned, to Mr. H. Agarwal, Learned Counsel, appearing for the petitioner. Also, the Learned Counsel for the petitioner would be at liberty to make his submissions in the matter after perusing the said minutes.
It's in our favor, man, I don't need, only that date is only, it was the, basically whether the promotion was kept in a seal cover or not.
It was not kept.
This is in my favor only.
Where is the name of the petitioner here?
petitioner's name, my lord, will find at the end.
Huh?
The end of the paper, my lord. End of the list. I'll just.
To send us.
Yes, sir.
Okay, kept in seal cover till finalization of the department.
Now,
So
that-
now,
I was exonerated of the.
yes, he is exonerated now.
So
Open that.
seal cover was opened in 23, but the basis is 2021.
21.
That
So
was
he
open.
wants this promotion from 21, give it to him. That's
But-
all. You have retired.
Yes.
But my lord, there is a challenge to the speaking order, my lord, that has determined the retirement date as 1962, my lord. So let my lord that determination stay.
That
because
is already said that it will not be, no, my Lord Justice Suman Shyam's order.
Yes, yes.
That will hold the field. You have given an undertaking.
My lord, but that was not on merits because that observation has held that without going into the core controversy.
Page 53, my lord.
That is why we have not preferred a review, my lord, because so far lordships.
So and so, 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 so and so. So this 31/3/23 is a retirement by, on the basis of the determination made by you.
On that day, my lord, but my lord will see that
When would his original date of retirement be if your determination is to be upheld?
62, and his retirement will be in 2022, my lord.
Your lordship will see my admit card, or it is on the basis of the admit card. Please call. Admit card, please.
When did you actually retire? 31/3/23.
23. As per admit card, it ought to have been 2022. But that's why they were trying to recover that money, that they cannot do it. So even
So
if
you
it-
also agree that you will have to retire on 31/3/2022.
Yes.
So this
Yes,
period
yes.
of from 31/2/2022 to 31/2/2023, this will be sort of re-employment.
Yes.
And your promotion from 2021.
As assistant conservator of court.
And pension and all.
Will be
implying
calculated.
there.
That's the all.
Otherwise, the aspect of recovery is also them
Recovery, we will follow the
process.
once this order is there.
Yes.
So that period, he will get his pension. Pension will be fixed on 1/4/2022. Because he received salary till 31/3/2023, no pension. Pension starts from 1/4/2024. This period, we will seek as re-employment, contractual, whatever it's. The salary drawn be not recovered.
The page 71, your lordship may kindly see. That will be the impure order, the page 71. This was the order, page 71, the speaking order. First, page 71, the first one, we have no problem, my lord.
Just so.
Yes. Second.
You were promoted as ACF in
21.
No. You want it from 21.
It was given later on.
When?
Just 33 to 2023, page 27.
So that cannot be sustained. You are receiving your pension.
Provisional pension.
Page.
Page 71. This is on in WPC number 7350 of 2023. Item number 36. Page 71. First one will we have no problem because it is if my admit card is taken, then it will be 31/3/2022. Second, they can recover, my lord.
That we will take care.
Third, your lordship, that is again a different issue in another matter. Then 4, my lord.
So this promotion, you will not get it because this is admittedly after your retirement. So
Yes.
this we will uphold. We will direct them to open the seal cover.
No, it is open.
Open. Seal cover is
Seal cover open, man.
open. And
On
then this,
in 2023, it was open,
and then this was
leading to the
So
promotion.
now you give it from 21, notionally give him the benefit, pension, fix it. That's all.
Yes. But that determination, Lordship may keep it.
We will say 1462,
Yes.
he retires on 31/3/2022.
Yes, ma'am.
1/4/2022 to 31/3/2023, no recovery. But not service. So your decision that he will not be, that promotion given to him on 30/3/2023 is bad, upheld. But he will now be promoted from 2021. The period from 2021 till the date of his superannuation, that is in 31/3/2022, will be notionally fixed. The pay will be arrived at, and you release it. That's all. Anything more?
That is, and just liberty to, my lord, if so advised, under pension code, my lord, if the
When did he retire?
retired in 2023, man.
What do you want to proceed against him? On what ground?
If, my lord, the department is so advised, if
No, what is the advice the department will get?
if he can be proceeded under pension code, my lord, if any.
For what? What is the misconduct?
For, my lord, falsification of his birth record, my lord, because that is there in the speaking order.
When was that falsification detected?
Detected in 23.
23. You still have 4 years. You have time till 2007. Why are you bringing us into it? You proceed. You have 4 years, but you will have to demonstrate that this was not to your knowledge. It was discovered in 2023. Fraud vitiates everything. These are the 3 stages you will have to cross. Done.
That observation, lordship may.
Will not take. Because I don't have any material. This IAs and all are now.
Infractions in view of the order passed in the case.
IA is only. Junior, date my junior.
But the
The IA is on some juniors who were promoted from
Oh,
that day.
very good.
Yes.
Heard the learned counsel for the parties at length. Hearing concluded, registered to discuss this matter again on Monday. Today I can't. There is much. Monday for delivery of orders.
May I pay it on Tuesday, madam?
Tuesday you want it.
Monday I have a matter in
Tuesday.
Supreme Court.
Obliged.
Thing is, the memory is very short. So yeah.
This is the order of 18/1/2023. Now more than 3.5 years. The relevant portion paragraph, page 25, paragraph 60.
Have you got the money?
No.
Yes, madam.
Lordship, I'm appearing on behalf of Picos. We have the up-to-date instruction, Lordship.
Last occasion, my lord, some undertaking was given in the first week of August. All process will be completed.
The procedure. Yes.
The budget is available, it should have been there. Then
Now, what is the query you have raised, Mr. Chalia?
not aware of the, we are not a party.
What is the query?
Lordship, query about the checklist, Lordship, with the
Checklist.
department has generated.
When was the order passed by this court? 23.
Yes.
23.
My lord.
For the last 3 years, you are still with the query stage, playing around.
No, Lordship.
Huh?
According to the instruction, we have
The
intimated
learned counsel for the respondents to receive updated instruction as to why the area salaries of the petitioner was not released to him till date. Although the budget provisions seems to have been provided for the same. Also, Registry to list this matter again on Monday. 24. Ms. Chalia, Mr. Chalia, please have your instructions. Madam, you also have it.
Yes, ma'am.
And this is going beyond. 3 years you're playing around query. Now we will start query.
And deep.
May it please your lordship. In connection with this matter, lordship, we have approached the division bench lordship. Appeal is pending, lordship.
What states the